Good morning, good morning, good morning, amazing Leonard. And depending where you are, good afternoon, good evening, good replay crew. Good to see you. It's Thursday. It's June 18th. We are back in Massachusetts today. I think we're going to fly for everybody who missed our flight yesterday and was like, I missed the flight yesterday. Don't worry. Don't worry. We'll fly again today. We've got you. We'll fly again today because we are back in Massachusetts for kind of part 2 of yesterday's stream, covering all of the discovery fighting that is happening, specifically at the moment about whether or not Colin Albert will be deposed and when. I have a fresh cup of coffee. We are going to be here. We've got a hearing yesterday. Also, there are a few times where I see the hearings in advance. This is one of those times because yesterday's hearing, the judge didn't seem to be microphoned at all. And so I went through yesterday's hearing and gained up the judge so that we could hear him better because it was rage inducing to me. I was sitting there going, I can't hear what you're saying. I want to know what the judge is going to do. I want to know what the judge is going to do. And I could not hear him. So I went through the hearing and gained up the audio on the judge. So if you notice that the background sound shifts a little when the judge speaks, that's because of me. So spoilers, nothing really gets resolved. I feel like I could say that about every hearing we've watched lately. Have we watched a hearing lately where we've been like, great, that settles that? Right. Every single hearing we've watched lately, it's been like, and then this, and then this, and then this, and then EDB crashes out. That's how I feel. That's how I feel. So I've got coffee. I've got plenty of cursey words. I've got court. I've got chat. We've got coffee, chat, court, and cursey words. What else do you need? Oh, and a bunch of cardinals as well. Let's keep going. Anybody else out there? Do we have any crows? No turkeys yet. So there we go. Coffee, court, chat, cardinals. Cursey words. We got everything we need. We got everything we need. Oh my goodness. All right. Let's just roll the intro. Here's what we're going to do today. For those of you that are like, Emily, what are we doing? We're going to go over the documents we didn't finish yesterday because I wanted to attend court. We're going to talk about court being a whole thing yesterday. And then we are going to go to court. And then we're going to answer all the questions that we didn't get to yesterday and today. So documents, court, questions. Yes? We've got plenty of time. All right. Law nerds, it's good to see you. Happy Thursday. Happy to be here. Let me know where you're coming in from, what you're drinking. Everyone who saw me staying up way too late in the Ryan Hall y'all chat, good to see you. How you doing today? Hopefully you're well. Yesterday was much. I hope you're doing okay. And for those of you that are tired and safe, good. For those of you that have had much more difficult nights, I am so sorry. It was a lot yesterday. So I'm glad you are safe. I'm glad you are well. I will see you in a second. Let's roll the intro. Let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I know, don't worry. We're going to do a brief road so far. We'll fly to Massachusetts before our court hearing. We got to let those who also straggle into chat, because it's like we're on EDB time and then EDB time slips into other forms of time. We're gonna fly when we get to court, but we're gonna do a quick road so far from yesterday, and then we are going to go to court. Hopefully that makes sense. I was spending a lot of time organizing yesterday because my notes and my court prep and the everything had just gotten a little out of control, and it reached the like ADHD rage where I'm like, today is the day. Today is the day, or tonight is the night. We are dealing with it. We are going to take whatever time it takes, and we are going to fix it, and it is going to be fine. It is going to be fine. So I was organizing yesterday. I feel much better, a little tired, but I feel much better. So for all of you that were like, Emily, you were up very late. I was going to be up late anyway. Having Ryan covering the weather, like I like to put on a stream while I'm working too, y'all. But I don't want to listen to myself. So I love listening to a weather stream. So let's do a quick road so far on what was going on yesterday. This has all been brewing for, more than a moment at this point, because the Karen Read civil cases now have spawned their own multiverse. First, it was the criminal case, and then criminal case take two. During the pendency of the criminal case, the O'Keeffes et al. So the O'Keeffes individually, and then as representative of the estates, and then as, trustees. Well, I think one of the children is now over 18, but as trustees for one of the children, et cetera, are suing Karen Read and C.F. McCarthy's and the Waterfall through their corporate entities, the bars, for essentially dram shop, saying, hey, Karen Read was overserved. It is in their best interest if Karen Read wins her wrongful death, because if she proves that she is not responsible for the death, then the bars can't possibly be responsible for serving her or not serving her. I also think there's a world where even if a jury thinks that Karen Read is responsible for John O'Keeffe's death, listen to me, chat, even if a jury thinks, we're talking about potential jury outcomes. I know you're not going to agree. Potential jury outcomes, even if a jury finds that she is in some way responsible, because the standard at civil is different and they are looking at different things, I still think finding that she was overserved is going to be difficult based on the testimony we've seen at trial, unless something different happens. So the bars are there too. And then we have the next in the series of lawsuits, which was Karen Read sues everybody. Remember, Karen Read, that my throat just decided to stop, which is Karen Read sues everybody. Remember, Karen Read's attorneys had originally said they wanted to bring those causes of actions into the wrongful death case, which means the wrongful death case would have been like all the O'Keefe parties versus Karen Read, and then Karen Read versus everyone that was in the house, and Tully and Buchanan and Proctor et al. So it would have been two cases with facts that are interconnected, because part of Karen Read's defense is, of course, going to be A, they set me up, B, they know what happened, I'm not responsible, they're responsible. It's going to be part of that case. They didn't bring it. They brought it in state court. It got removed to federal court. That is now Karen Read sues everybody in federal court. Then all of those in the House sued Karen Read and Aidan Carney for defamation, intentional infliction of emotional distress, negligent infliction of emotional distress, conspiracy to aid and abet each other with the emotional distress. I don't even know if you can do that. I'm real curious to see, because I'm like, can you have an aiding and abetting intentional infliction of emotional distress? Maybe you can. It's new to me. Real curious. So they brought that in state court, and then it got removed into the same state court because they filed it elsewhere. It got removed into the same state court that the wrongful death case is in. They didn't bring it as causes of actions under Karen Read sues all of them. So now that's in state court. And then the tail end of the multiverse, as we have it now, Karen Read sued MSP and Canton. So all of these cases have different timings for discovery, different parties, and all of the different things. And so there is truly a multiverse going on with the lawyers, and nothing is consolidated into one discovery plan or one case. The wrongful death and the Karen Read sues everybody are currently before the same judge the wrongful death case and the House defendant suing for defamation at SEC are currently before the same judge in the same court. Karen Read sues everybody is in federal court because of that 1983 action. Yes, you could do it in state court. They didn't want to. Yada, yada. It's in federal court. And then Karen Read sues law enforcement, I imagine will also end up before the same judge at some point. It's just not there yet. So now we are in the setting for everyone fighting over discovery. Early on in the wrongful death case, remember Trooper former trooper Michael Proctor, was asking in the federal court for discovery to help him prep for his deposition. And we covered that when he was also trying to get out of his deposition. And the court's like, go to deposition tomorrow. And all the attorneys are like, so we can't do that. About that, we can't do that. We can't do that. So then we have continued to see the court say, what depositions do you have set? What discovery has been done? What could be more egregious? What discovery has been done? What hasn't been done? We have seen the court. What depots do you have? What depots don't you have? Why is nothing happening? Why isn't anybody ready? And the court is starting to fume. And so we have watched a few hearings leading up to this hearing that happened yesterday afternoon. And the judge has consistently been like, well, when do you have depositions? Do you have depositions today? Do you have depositions tomorrow? What's the schedule of depositions? And the judge has actually said, give me a list. Who subpoenaed the depot? When, what, how, where, who? Give me the information. And then as we got into the documents yesterday, we start to understand better, I think, the back and forth that happened maybe 2 hearings ago between Karen Reed's attorney Rosenberg, and yes, there are a number of them, and plaintiff's counsel Diller, and yes, there are a number of plaintiff's counsel. But Rosenberg and Diller were going back and forth regarding whether or not Colin Albert had been deposed. And Diller was like vague posting like IRL, just being like, well, I know that they canceled the deposition and then this and this and this. And Rosenberg's like, what are you talking about? And the court's like, we're not talking to you. And it was so confusing because Rosenberg said that they had subpoenaed Colin Albert for deposition and Colin Albert had not appeared for deposition and they hadn't gotten a deposition done. And Diller was like, well, actually, Colin Albert was deposed and actually this depot was doing this and actually. And I was like, what is happening? Was there a depot? Was there not a depot? Why is it so confusing? Well, yesterday, some light was shed upon why it was so confusing. And this is why. It's because it's some snake shit. My opinion. You let me know. My opinion that it's some snake shit. Because what we learned yesterday in the filings was that Karen Reed's team had subpoenaed Colin Albert for deposition and asked for a bunch of documents. I think it's overbroad. I agree. However, is that unknown to civil law that you ask for everything and then hope that it gets narrowed down? No, because if you don't ask for it, then they're going to be like, well, you didn't really ask for that. So you go broad and then you narrow it down, right? This is not shocking to me. And it seemed that Karen Reed's lawyers said to Colin Albert's lawyer, hey, if you're not going to give us the document production before the deposition, it doesn't make sense for us to go forward with a deposition until we have the documents. So we are going to continue the deposition until we get the documents. And if we have to go to court and fight over the documents, then we have to go to court and fight over the documents. Also, if my light keeps changing, it's the outside. The weather's going to be spicy around here today. So the lights may continue to change. I will do my best to mitigate, but it's not you. It's not your TV. It's me. Weather is dynamic. Weather and streaming together are dynamic. So I know, I saw it too. I was looking at the screen. I'm like, am I now sitting in the dark? No, it's the outside. If I go green and then my stream disappears, I'll keep you posted in the app. I'm teasing. It shouldn't be that kind of weather just yet. So Karen Reed's attorneys were like, we want the documents. They're like, we don't have the documents. We're not giving you the documents. We're not doing the things with the documents. And everybody's like, fine, we'll put over the deposition until we deal with the documents. And then Karen Reed's attorney said, and I am unavailable these days. And then somehow, magically, as if by TikTok psychic, Diller discovered that Colin Albert wasn't going to be doing his deposition with Karen Reed's team and was magically available. And so they subpoenaed, the plaintiffs subpoenaed Colin Albert for deposition. and scheduled it for the days that Karen Reed's attorneys were unavailable, and had already told Colin Albert's lawyer that they were unavailable. And so they just went like boop, and they scheduled a deposition of Colin Albert. And I think that some of the disagreement is between the two depositions. And I think there's a world where it's possible that Colin Albert went to the plaintiff deposition, but still has not gone to the defense deposition. And this is where some of the fighting continues, because the plaintiffs like swooped in and were like, we'll do that deposition on the day that they're unavailable. Wild stuff. And then they gave short notice, and we saw all of that complained of in the filing from Reed's attorneys yesterday. So the positioning from the plaintiffs in this case, Diller's clients, were that Reed's team had canceled the deposition without having a conversation, it seems, with Reed's team. Reed's team is like, we didn't cancel it. We needed to reschedule it because we needed the documents. Reasonable. So there is a disconnect in how everyone has purported this happening. And now we get to the opposition that we didn't finish yesterday, because we started to see this unfolding, including allegations from Reed's team that when Colin Albert was at 34 Fairview and how he was picked up and who picked him up and when he went home, all of that is in dispute for them. And the other side is saying none of this is in dispute. So we've got some interesting things to see. I've got a fuzz. Apologies, chat. There was always fuzz because my cats love to be on my desk in the morning before I stream, because they enjoy watching the birds. So, DMN874 said there's not enough Sam Adams to get through this, especially after the Tartan Army drank Massachusetts out of Sam Adams. So yes, there is no Sam Adams. And there's definitely not enough to get through all of this. The reason I say it's snaky is because the attorneys seemingly being like, well, they're rescheduling it and we're available these days, is wild. And then Colin Albert's lawyers coming in and being like, oh, by the way, you have 10 days to take his deposition or he's like permanently unavailable because he's joining the military, is also wild work. And they're like, well, we didn't know. I can't imagine that you only have 10 days. Maybe it's true. I don't know. But it seems to me that you would have more than maybe 10 days heads up that you're going to boot camp. Seems like that window seems short to me. Maybe I'm wrong, but that seems like a real short window. So let's take a look at the opposition that we didn't get to yesterday. Then we're going to look at the reply, and then we're going to go to court. Does that make sense for everybody? Hopefully that makes sense for everybody, because that's where we're starting. Hopefully that road so far helped. And let's see. A lot of you are saying, no, you know well in advance when you're going to boot camp. It's a much longer process. And some people are saying sometimes you actually don't. I mean, I've had military friends that have been upended on moves that are surprising in short periods of time. I didn't know about boot camp, but it just seems odd. It just seems odd. It just seems odd to me. Either way, not a process I'm super familiar with. Law nerds in the chat know more about this than me. For all of you that know this, thank you for your service. Thank you for your service. I appreciate you. And that includes all the mill spouses and mill families, because it's not just the person in the service who also's life is impacted by being in the service. So thanks, y'all. All right. Are we ready to get to this opposition? We started it yesterday. It was spicy. It was more spicy than I thought it was going to be. Let's get into that. More spice. It's like more cowbell, but the legal version of it. I know. Chat is like, Colin's being rehomed. Yep. I'm still going to drink my coffee while we're doing this, though. Non-party Colin Albert's memorandum of law in opposition to defendant Karen Reed's motion to compel. starting back where we left off yesterday, non-party Colin Albert, by his counsel, respectfully submits this memorandum of law in opposition. Karen Reed's motion is of a piece with her cynical, years-long campaign to scapegoat Colin and many others in order to deflect from her own culpability for Officer John O'Keefe's death. Just spicy. Just spicy. Reed's motion, they say, is littered with misrepresentations, thoroughly debunked claims, cheap character attacks, and outright knowing falsehoods that have no place in court filings. It seems that this case is just going that direction, though. It seems that we're here now. They say on the dispositive issue before this court, whether Reed is responsible for the death of John O'Keefe, Colin has virtually zero relevance. So you agree. There is relevance. You can't say no relevance because it's not true. The modifier virtually is interesting. Why don't we just leave it? They go on to say it is undisputed, bold and italicized, that Colin was not present at 34 Fairview Road when Reed and Officer O'Keefe arrived in Reed's car in front of the home. The other side disagrees that that is undisputed, meaning it is in fact disputed. How can you accuse the other side of being littered with material misrepresentations when you say that it is undisputed, when in fact it's disputed? Huh? Anyway, they say that in any event, whatever marginally relevant evidence Colin may possess does not justify the extraordinary burden imposed upon him, a non-party, by this subpoena. The subpoena is breathtaking in scope. We can't say that they're not also trying to match wits on the sassy writing. So there's that. Y'all can disagree, but they're definitely trying it with the sassy writing. They're like, oh, it's my turn now. Hey, you know what? I'm not mad at the lawyers for trying. I can distinguish the sassiness of the writing from the arguments being made, and I am amused by the sassiness. We're just like, what are we doing? Like, it's so dramatic. It's just so dramatic. It is an overbroad subpoena. It is an overbroad subpoena, but it is breathtaking in scope. It's so dramatic. So dramatic. It seeks, sorry, my in-ears are pulling on me this morning and just, they're touching me. You know what I mean? If you know, you know. It's one of those mornings where this in-ear is like, I don't like it. They say that it seeks documents and communications entirely unrelated to the death of Officer O'Keefe. I mean, I think the other side would say, well, we don't know they're unrelated until we know that they're unrelated. It demands, among other things, all communications with no fewer than 12 individuals. Yeah, too much. Too much. Including Colin's own mother and father. I mean, there's relevance there, though. This is the problem. Spanning over 4 years without any relevance to the death of Officer O'Keefe. Too big. Too big. They've embiggened it too much. I don't disagree that it's overbroad. They say that these requests are not tailored to any discrete issue in the wrongful death action or, indeed, any discrete issue at all. They had to throw that in there. They are not tailored, period. They are not curated to avoid undue burden upon a third party. Sometimes it can be overdone in one sentence, though. There's a balance to the legal filing sass, and you've got to find the well-placed balance on the sass. But I appreciate the use of curated. They say Colin agreed to and did review his records for all communications with police officers pertaining to the investigation into the death of Officer O'Keefe and Reed's criminal trials, and all communications around January 29th, 2022 regarding the investigation into the death of Officer O'Keefe. Now I think that scope is too narrow. Because do you see how they parse that? Do you see how they parsed it? Let's look at how they narrowed this scope just real quick. All communications with police officers pertaining to the investigation into the death of Officer O'Keefe and Reed's criminal trials. That's just to law enforcement. Do you think Colin Albert's directly texting members of law enforcement? Unlikely. He's probably talking to his mom and his friends about it more than he's directly texting law enforcement. And then let's look at the next narrowing. All communications around January 29th regarding the investigation. How do you define regarding the investigation? Communications about who picked someone up, who was where, who saw what. Is that regarding the investigation? How do you define regarding the investigation? So I think this has narrowed this down a bit too far, because what counts as regarding the investigation? I can imagine a whole world of conversations that are what Reed's team is looking for that aren't regarding the investigation and aren't directly with members of law enforcement. So I think that over narrows the issue. And I can see why Reed's team is just like, well, of course, this is overly narrowed. They go on to say that Colin had no responsive communications to the way that they narrowed it down, except a text exchange with Allie McCabe confirming that the two arranged for Allie to pick up Colin, or Allie arranged to pick Colin up at 34 Fairview at 12:10 a.m. on January 29th, 2022, a text Reed has had since 2023. And Reed's team made their objections to the issues they see with that text in their filing that we covered yesterday. Reed's demand for deposition is equally flawed. On April 21st, Reed served Colin with a deposition subpoena for April 29th, commanding his appearance just 8 days later. Despite the short notice to a third-party witness, I thought it was a 7-day notice period. Maybe it was an 8-day notice period. That might be right on the notice period. They say that he was ready and able to appear for the deposition. However, they say Reed canceled the deposition less than 48 hours prior and never issued a new subpoena. Reed is moving to compel against a non-existent subpoena. Right. All of you are saying the notice period is 7 days. I thought it was 7 days. Right. This is right at the notice. This is not a short notice period. This is the requisite notice period. Plus a day. The thing is, we now see why Reed's team is saying we never canceled the subpoena. They are saying you can't compel a subpoena that's moot, because if the subpoena day passes and you've not extended it, it doesn't have any force and effect. Reed's team says they all agreed to extend the subpoena because they didn't have the documents. Colin Albert's lawyer is saying, no, we didn't. You canceled the deposition. Subpoena's done. Dead in the water. Nothing you can do. Continuing. On May 19th, 2026, Colin's counsel learned that Colin had applied to enlist in the United States Army, and on May 20th, the application was approved. As a result of his enlistment, he was ordered to report to basic training outside of Massachusetts on June 2nd. On the same day, May 20th, Colin's counsel informed Reed's counsel if they intended to reschedule the deposition after canceling it, he would have limited availability, and offered the only dates on which he was available before the extended absence beyond the close of fact discovery. Remember, discovery ends in August. This all seems way fast. This seems way fast. Also, I have more questions. I'm not going to ask them at the moment. I just have a lot more questions. I'll wait and see if they come to light in other ways. They then go on to say, no, here's one thing. One thing. I don't know why. You pick your one thing. I'm going with Lincoln Park today. Here's one thing I'm thinking. If they were all fighting about whether this subpoena was canceled for the April 29th deposition, it might explain all of the questions all of y'all have about, well, if the military knew there was an open subpoena, wouldn't that be an issue? And here's the thing. Hyperbole. Did the military accept him with an open subpoena? Their side's arguing that the subpoena was canceled, and so there was no subpoena. So I imagine that this is my speculation. I don't want to hear EDB says that this is a fact for sure. I do not know. The way they are arguing this, I wonder if this did A, not come up, and B, was not reported because they do not see it. They're saying we don't see it as an open subpoena. Because this is now a disagreement of whether the subpoena is open or not. They say the subpoena was canceled. So I wonder if that's what was shared with the military. I'm curious. So there is a disagreement. They have set up a disagreement of fact here. So it would not surprise me if they were like, fine. This also seems like a very fast turnaround to file an enlistment application on May 19th and be like, yeah, we got a date for you June 2nd. Seems quick to me. I don't know. It took me, how long did it take me from the time I got hired with the DA's office till start date? It was months. It was months of stuff that we had to do before I started. A lot of you are asking if he's a plaintiff on the defamation case. Let me look real quick. I don't think he is a plaintiff on the defamation case. This is an excellent point. Thank you, chat. I thought it was just the other House defendants, but he is a plaintiff on the defamation case. This is a fair reminder. We haven't covered the defamation case a ton, but I'm just pulling up here. Let me just pull up the original complaint. I'm not pulling up the amended complaint. We haven't gone over that yet. We will another day. Today is not the day. It's a lot. This has also been moved out of Barnstable. Barney. This has been moved to Plymouth. But Jennifer McCabe, Brian Albert, Colin Albert, Brian Higgins as the plaintiffs. Well, that he definitely has to disclose. That he definitely has to disclose. There's no getting around that one. I can see an argument for, I thought it was canceled. That one's unavoidable because that was filed April 16th, a month before he filled out enlistment papers, I suppose. So, Firecracker said if he lied on his enlistment form about not having pending litigation, he can get himself in a lot of trouble. Oh, I imagine a lot of trouble. I also can't imagine on any background check, this wouldn't come up. Just by the amount of internet traffic connecting his name to these cases. So, I can't imagine this doesn't come up. But we'll see. I guess we'll find out more, or maybe we won't. Maybe we will. Either way, there are things here that are that defy a little bit of logic in my mind. that I am curious about. Because, hey, the timing of this seems odd to me. I'm open to being wrong, but we're putting a flag on it. We're yellow flagging this one. Yellow flag on the field for some of the timing on this. I don't have enough info to red flag. Yellow flag. Continuing on. May 19th, he applied, they say, to enlist in the Army. May 20th, he was approved. June 2nd, he was shipping out of Boston, apparently, for, they say, basic training. They go on to say, on May 20th, Colin Albert's counsel informed Reed's counsel that if they intended to reschedule Colin's deposition after canceling it, listen to the language on that. If they intended to reschedule after canceling it, he would have limited availability and offered only dates on which he was available before this extended absence beyond the close of fact discovery. Reed's counsel declined those dates despite having 10 attorneys capable of taking his deposition and the fact that Reed was supposedly ready to take his deposition on April 29th. Different lawyers, everybody. Instead, Reed, without indicating whether any of her other nine counsels, I think a lot of lawyers do not view themselves as interchangeable, but the lawyer who's prepped for this deposition can't just like tag somebody else in. You know, I don't know the track equivalent or most sports ball equivalent, but I swam a number of relays as a swimmer and swam butterfly. I wasn't just like tagging in our backstroker and being like, hey, can you just swap out for me? It's like, well, there's 3 other swimmers on this team. Why can't you just interchange them? No, nobody was tagging me in and be like, girl, go do the breaststroke. Are you kidding me? Do you want to see me flail embarrassingly? I can't do that. Just tag somebody in. Just go tag somebody in. Nope. These attorneys are working on a entire, like you have 10 attorneys, but you also have 4 separate lawsuits. So to think that any attorney is just going to tag in and take the deposition also doesn't make sense. I love this so much. April, thank you to your hubby. April H said, my hubby is a recruiter. He said it's normally 1 to 3 months, but it's been 5 to 10 days for the last few months because of the war. Thank you, April. This is helpful to know that it is possible, even though it defies all of our brains, that they are fast tracking things. This makes sense. Thank you so much, April. So there is a possibility of fast track. That raises the question that they might not have had time to start searching all the things that they would have done if they took a couple of months, which means they might actually find out about this. They might actually find out about this in a way that they're not thrilled with. Oh boy. Oh boy. Thank you for that. This sets up a whole lot of other issues that they might find out about this in a less happy way. Fujo says it's been on the news. I appreciate that. Yeah, the news that crosses my algorithm is what people are doing in their gardens, what concerts are near me, what the playlist for the last Dave Matthews Band show is, that Yuri Buchanan was at the Dave Matthews Band show in Mansfield. The things that pop across my news and like other news are definitely not the same. So I am unaware. And then all of the football fans coming to the States and being like, Buc-ee's is a lot. That. That. I've been enjoying that. So thank you. Continuing on. Thank you. Thank you, April. Tell hubby thank you. Sparkling Rutabaga said, this is my news stream, right? This is how you found out that Boston ran out of beer. That's what's on my news feed. I try to keep it that way. Continuing on. They said that Reed's other 9 counsel were unable to take Colin's deposition prior to June 2nd and demanded that Colin, a third party in this lawsuit, sit for deposition on dates when he would be unavailable. Then, on May 22nd, Colin received a deposition subpoena from plaintiff's counsel after the plaintiff's counsel learned of Colin's limited availability. Notice how they sidestepped that? Emily, is today just an exercise in reading between the spacing? We're reading between the lines here. How? How did plaintiff's counsel magically learn of Colin's limited availability? It came to him in a dream? Sure, Jan. Plaintiff's counsel learned of Colin's limited availability and scheduled his deposition for May 29th. All counsel to this action, except Reed, attended Colin's deposition that day. And this is setting up the issue. That when I was so confused in court about them talking about there was a deposition here, there was a deposition there, there's 2 depositions. Because plaintiffs noticed a deposition and everyone else showed up and was like, we're at deposition. Reed had subpoenaed Colin Albert. They had rescheduled the deposition because of the dispute over documents, said we are unavailable these days. Plaintiff then subpoenaed Colin Albert on a day that Reed's counsel was specifically unavailable, and everyone else went to the deposition. Curious that when we talk about the gamesmanship in civil law that pisses me off so much, this is it. So, ELA said, but how can Diddler do that without informing Reed? Oh, Reed's team was informed they were unavailable. They went ahead with it anyway. Reed's team was informed. It was short notice, but Reed's team was given notice. It was just short notice. And Reed's team was like, we've already told the lawyers for Colin Albert that we were unavailable. Now, my supposition, and maybe I'm wrong, my gut on this is that there was a conversation. Hey, he's only available till June 2nd. Reed's attorneys aren't available these days. Schedule it when you want. I'm not telling you what to do. Schedule it when you want. You do you. We can be there anytime before June 2nd, boo-boo. You do you. And they're like, oh, the 29th. Works for all of us. I guess they'll figure it out. I hate this shit. I hate this shit. It makes it so much more expensive for everyone. Remember, Diller also was the one who scheduled a deposition tomorrow, Friday, which is a national holiday for Juneteenth, scheduled depositions for Friday, and Reed's team was like, we're not available. And the court is like, well, we got to find our way to be available. I don't know why the court just turned into Gollum for me. Apologies. The court was just like, everybody's off that day. Why can't we do a deposition? And Reed's team is like, because it's a federal holiday, Your Honor. We're not doing a deposition. We're unavailable. So Diller's done this a couple times. Oh, this annoys me so. This annoys me so much. If your case is that strong, you don't need to fuck around to win. If you have a strong case, you don't need any of this to win. So they say all counsel except Reed attended the deposition May 29th. So now we know, according to these attorneys, that Colin's deposition that Reed's subpoena was rescheduled, but the deposition that plaintiffs scheduled went forward. Proud Canadian 6506 said, let us not forget when he didn't want to delete the accidentally sent email. Oh no, Diller has pulled some fuckery in this case. We haven't even gotten into any of it. They have to know publicity. It makes them seem so much worse. I don't know if they think that they're winning. It's just, Judy, you got this. Good to see you in the chat. Said, Your Honor, Exhibit A as to why EDB is not a civil attorney. The way I worked before I became a district attorney, I worked in civil as a research attorney for two very smart civil judges. And I just adored them. One of them was terrifying to most of the lawyers in the courthouse. This is a judge people didn't want their cases in front of. This was a judge who had very, very, very limited tolerance for this kind of shit. And I fucking loved it. I loved it. Because when I was like, Your Honor, the third time they're doing this, he's like, no, it's not. And then the lawyers would get into court. He's like, explain to me why I should not sanction everyone. It was so good. The lawyers were like, there is no leeway. And you know what happened? You know what happened when there was no leeway? The same thing that happens when you're in school. By the time you get to like high school, college, whatever, you've got that one teacher, that one professor who will never fuck around. And you know what you do? Your shit gets done for them first. Yeah, they're not the ones you fuck with. Someone else, it's like, oh yeah, I need a little bit more time for this and this and that. But you get your shit done for the one that will give you no leeway. And so his cases moved along pretty quick, just because everybody else was just like, he's not going to give us any wiggle room. And magically, when there were boundaries, the lawyers got all their shit done, unless there was actually a real issue. And if there was a real issue, he would hear it out. But the bullshit back and forth, nope. And all the lawyers knew it. His reputation preceded him. And so his cases got handled orderly. Now, I'm sure they called him every name in the book behind his back because he absolutely was a hard ass, but he was fair. And he had no tolerance for bullshit. Get your work done. I don't give a shit. I don't want to hear about it. Get it done. Y'all, you're civil attorneys. You chose to be here. Get your shit done. What are you doing? He was very smart, very fair, with a very low threshold for bullshit. I loved it. So I would go in and be like, Your Honor. Oh, I was such a tattletale. Farrah, it was my whole job. I loved it. Farrah said, not you being a tattletale. I was his research attorney. My job is to keep the court informed of what's going on. And I'm going to keep the court informed, Your Honor. They went over the page limits without requesting a page limit extension. Do you mind reminding counsel that that's unacceptable? Your Honor, they filed this 3 days late. I don't know if you want to hear it or not, but just so you know, they filed it late. Oh no, I gave him all the fodder at the beginning. Like the things people did wrong were at the top of the memo. Because I would help write opinions and stuff like that. So no, it's just keeping the judge informed of what the lawyers are doing. Also, if you're going to email me and be like, I know that the filing deadline is this and this and this, but can we? I don't have time. No, we got a lot of cases. We're busy. Don't try to email me and be like, can we just? No. Some of these lawyers are bringing me boxes of motions for summary judgment. Get your shit done on time. It was long work hours. Long work hours. Loved the judges I worked for. So And there were times that he would remind the lawyers about the deadlines and still hear their stuff anyway. And there were times he was like, this is untimely. Why shouldn't I sanction you? Loved it. Continuing on. Jacobson, 87, said, Emily, my favorite teacher, told me 4 days after switching schools, you all have the same homework, no excuse. No excuse that I did not have the books yet. Yeah, y'all have the same homework. Figure it out. And the thing is, when you set the expectation, most will be able to meet it. If you set the expectation that there is always going to be more time, there is always going to be one more chance, then there really is no expectation. And it's amazing that then other cases will take priority because all these attorneys have other cases. If this is the judge that's going to be like, fine, you have one more time, fine, you have one more time, fine, you have one more time, then this is the case that's going to get put on the back burner because the judge is going to acquiesce to it. And then there's no consequence. So if you're the judge who's like, look, here comes a consequence, then shit gets done. Just saying. I'm not a judge, not my courtroom to run, but it seems like nobody's busy enough because they're not getting shit done. Continuing on. With the oops-a-doodle, Colin's no longer available. Oops-a-doodle. Everyone's available for his deposition except for Reed's attorneys. Whoopsies. They go on to say that compounding the issues on June 3rd, Reed's counsel falsely told this court, oh, fucking hell, here we go. Here the fuck we go. We covered this yesterday with Docket 111. Docket 111 was Rosenberg telling the court, Colin Albert's lawyer wanted me to correct the record and let you know, blah, 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 blah. Here's Colin Albert's lawyer again saying that Reed's counsel falsely told the court that Colin had refused to appear for deposition. This was an unequivocal false statement that appears to have been designed to prejudice third-party Colin before the motion was even filed. This misrepresentation to the court in violation of Massachusetts Rules of Professional Conduct 3.3a and Reed's refusal to genuinely remedy the misrepresentation further warrants denial of this motion as a sanction. Refusal to genuinely remedy the misrepresentation further. The lawyer filed a letter to the court and the court struck it from the record and said, what the fuck is this letter to the letters to the court do not get docketed. What are you doing? Get this out of here. And struck it from the record. Rather than accommodate a third-party witness schedule, Reed filed this motion, a classic hallmark of discovery designed to burden and harass rather than obtain information. Indeed, the only quote-unquote gamesmanship at play is that of Reed and her counsel, who have misrepresented to this court the circumstances of their attempts to seek discovery from Colin. And we haven't even gotten to the factual background yet. That was just the introduction. Oh boy. Factual background. They say that on the evening of January 28th, 2022, Colin was a 17-year-old senior at Canton High School. That evening, he was at his aunt and uncle's house at 34 Fairview, celebrating his cousin Brian Albert Jr.'s birthday, who also was on leave from the military. There's new information in that sentence. I had no idea. Brian Albert Jr. never, ever indicated that when he testified. I remember Brian Albert Jr.'s testimony. Brian Albert Jr. seemed like he didn't want anything to do with any of this. He was just like, nope, 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 nope. So, interesting. They go on to say, along with a few of his cousin's friends, At 11:55 p.m., Colin texted his close friend Allie McCabe to coordinate a ride home because he had a midnight curfew. Allie texted back that she had to drive some other people home first. Okay. At 12:10 a.m., Allie texted Colin to say that she was quote unquote here. Colin responded, okay. And then Colin left 34 Fairview at that time. See Exhibit 2. On his way outside, Colin saw his aunt Nicole Albert. However, I don't remember that. However, Colin never saw Reed or Officer O'Keefe. Instead, the undisputed evidence reflects that Reed had not left the Waterfall Bar and Grill until after Colin left 34 Fairview. Allie drove Colin home, where Colin remained for the rest of the evening. The defamation campaign against Colin. Oh boy. We're only on page 4. Y'all, we're only on page 4. What does this have to do with the motion at hand, counsel? If you're going to complain about the other counsel, what are we doing? Okay. The initial aftermath of Officer O'Keefe's death largely did not impact Colin. Colin was not present and was not a witness. He also barely knew Officer O'Keefe, who lived in Colin's former neighborhood. Following the initial shock, Colin's high school life returned to normal as he prepared for post-high school plans at Bridgewater State University and then started freshman year there. What, in 2023 then? They say that all changed on April 12th, 2023, when Reed and her counsel publicly and falsely accused Colin of being responsible for Officer O'Keefe's death. Reed had no actual evidence to support that claim. Instead, months later, her counsel, attorney David Yannetti, they're just doing the whole thing. Okay. All right. We're getting into the whole other lawsuit. Thank you, chat, for pointing out he's a plaintiff in the defamation case. I had completely forgotten about that. Instead, months later, her counsel, attorney David Yannetti, would claim an individual called with a tip and identified Colin and his uncle as the responsible parties. I remember that going slightly differently, but I'm not going to quibble with it. At the moment, this is their motion. This is their opposition. They're going to say what they're going to say. That individual was eventually identified as, that individual was identified? Interesting. That individual was eventually identified as Steve Scanlon, a Canton resident who previously admitted that he had no personal knowledge of the events of January 29th, 2022. That's going to be interesting if it comes out in the defamation case. And that prior to meeting with Yannetti, he had never heard of Colin Albert. Investigative memo from Sergeant Yuri Buchanan and Detective Brian Tully regarding interview with Scanlon. Does Yannetti agree that that's the same person? I have so many questions. Neuropsych said, why defend Colin so vigorously? Because this is Colin's lawyer. So that's their job on this. And he's a plaintiff against Reed in the other case. And they're trying to depose him in this case. So, yeah, that's that. Purple Moss said, I thought Colin dropped his part of the defamation lawsuit unless he dropped as a plaintiff in the first amended complaint. Let me just pull up the face page of the first amended complaint real quick. We have not gone over the first amended complaint. We're not going to do so today. We're not going to have time. He's still in the title of the first amended complaint. So he's still suing in the first amended complaint. So no. Konzadog said, this is Colin's attorney. Yes, the motion that we're reading is Colin's opposition to Karen Reed's motion to compel his deposition and document discovery. So this is Colin's lawyer that is writing this. So Colin's lawyer is the one that's opposing this, not the plaintiffs in this case. And then Colin is a plaintiff in the defamation case. I know. It's a lot. It's a multiverse of lawyers and litigants. Interesting that they say that the memo from Buchanan to Tully regarding the interview says that that's the person who called Yannetti and said to look at the people in the house. Interesting. They go on to say further, days after Reed's April 12th court filing, in coordination with Reed, blogger Aidan Carney published his blog in which he accused, without any supporting evidence, Colin of killing Officer O'Keefe. The centerpiece of Reed and Carney's false accusations against Colin was a Facebook photo taken, bold and italicized, a month after Officer O'Keefe's death, showing Colin had scraped knuckles on his right hand. Reed's reliance on this photograph in the motion to imply that Colin killed Officer O'Keefe is a misrepresentation. Indeed, they say, prior to her first criminal trial, Reed possessed photographs of Colin taken after Officer O'Keefe's death and prior to the Facebook photo that clearly show no scrapes on Colin's knuckles or injuries to his knuckles. If that exists, that will be key in the defamation case too. But part of the question in the defamation case will be when they were aware of this. That's going to be a question in the defamation case. So they go on to say, I mean, it seems like we're going to need metadata for all of these photos, right? They go on to say that prior to her first criminal trial, Reed possessed other photographs of Colin taken after John O'Keefe's death prior to the Facebook photo, clearly showing no scrapes or injuries to his knuckles. For the court's convenience, samples of such photos with timestamps are displayed below. Timestamps aren't metadata. Worst photocopy in the history of the world of photos that purport to also have timestamps. They're going to need metadata on those. So, worst photocopy in the world. They say, in other words, as Reed well knows, the evidence she submitted to this court to lamely suggest that Colin may have sustained injuries to his knuckles in connection with the death of Officer O'Keefe could not possibly support her theory because earlier photographs show the absence of any injury. What? Also, did she submit photos to this court in any of the motions that we've seen? I don't think so. We're just going to need metadata. The impact of Reed's continued attack on Colin's character and reputation has been catastrophic, and that is why there's a defamation lawsuit. While such is the subject of a pending defamation act, keep reading, Emily. While such is the subject of pending defamation action brought by Colin against Reed and others, it is noteworthy for purposes of this court's consideration of the motion. Since Reed conjured up the baseless allegations that Colin was somehow involved in the death of Officer O'Keefe, Colin has had to drop out of college and has been continually harassed and defamed online. I'm going to need more information about the had to drop out of college. I have questions because it seems to me that his age demographic is not super in tune to the stuff this sector of the internet. But I've got a lot of questions. I got a lot of questions. And if so, that sucks. He should be able to go to college. But I still have questions because, well, I guess it'll come out in the defamation case. I'm putting a big question mark on that too, as to what what happened with college and how it tied it all back. So I've got questions. I don't think people should be harassed online. You know where I stand on that. That goes for Colin Albert, the McCabe's, Karen Reed. I don't think people should be harassed online. I have no control over that. I have control over how I act, but I don't have control over how others act. And we will see what happens in the defamation case. I'm curious. But again, it's the age demographic just, I have a really hard time thinking that his fellow students have harassed him out of college. I just have questions. They say dozens of individuals have confronted Colin both at home and at work, accusing him of being involved with a murder. That doesn't say school, which caused him to fear for his overall safety on a daily basis. Yeah, don't go real world with people. Nevertheless, they say Reed continues, even in the present motion, to push a baseless fantasy that Colin was somehow involved in the death of Officer O'Keefe, even though Reed and her counsel know their claims against Colin are patently false. I have questions, though. Did law enforcement know he was there and not mention it in any of the reports, and it all came out later in their notes? Because while they attack the investigation, that is somewhere that is valid to attack the investigation. And that's not Colin Albert's fault. That's the investigator's fault. But also, that's a fair thing to be questioned. If it's in the notes that he was there and then it's not mentioned in any of the reports, that's a fair question. It's also fair to ask why. Why was it not in any of the reports? And those attacks should land squarely at the feet of Proctor, Buchanan, and everyone else. Those are fair questions to ask. Okay, continuing on. Reed's April 21st, 2026 subpoena. The motion asserts that on February 11th, 2026, Ms. Reed's attorney properly served a notice of taking deposition of Colin Albert for April 29th. That assertion is misleading. Oh? Reed fails to disclose that such notice was never sent to Colin or his counsel. Don't you have to file the notice with the filings in court? They say instead, on April 21st, more than 2 months after Reed's attorney issued a notice of deposition to counsel of record, what? Okay. Reed's counsel personally served Colin with the subpoena at his home, commanding him to produce a trove of documents within 6 days and attend a deposition within 8 days. Instead, on April 21st, more than 2 months after Reed's attorney issued a notice of subpoena to counsel of record. Well, who's counsel of record? They say the notice was never sent to Colin or his counsel. Well, who was counsel of record then? If counsel of record was, do we see the 2 months after Reed's attorney issued a notice to counsel of record. So did they only send it to the plaintiffs? Because that doesn't seem right. Well, we'll get to the reply before we do this, because if it's counsel of record, then there's notice. On April 27th, 2026, undersigned counsel served responses and objections to the document requests obtained in the subpoena based on, inter alia, the request's overbreadth, vagueness, and ambiguity. At no point did Colin or his counsel object to the April 29th deposition date. Instead, Mr. Albert was ready, willing, and able to attend that deposition on April 29th. Yeah, attend that deposition without them having any of the documents. In response to Colin's responses and objections on April 27th, counsel for Reed requested dates and times to meet and confer pursuant to the Rule 9C, right? Because they're like, we're going to have a problem. In that same email, counsel for Reed wrote, quote, under the circumstances, it makes sense to take Colin Albert's deposition after all the documents are produced. Does that sound like they're canceling the deposition to you? How would you interpret that if you got that email? Undersigned counsel promptly responded seeking clarification regarding the deposition. To clarify, are you canceling the deposition scheduled for April 29th, 2026? Reed's counsel then responded in relevant part, confirmed that Wednesday's deposition will be rescheduled. Look at what they chose to bold and what they didn't. To clarify, are you canceling the deposition? Reed's counsel responded, confirmed that Wednesday's deposition will be rescheduled to a different date. You know, we can't even blame reading comprehension because it's not. It's gamesmanship. On April 28, 2026, undersigned counsel conferred with counsel for Reed regarding the scope of the document requests. At the conference, undersigned counsel first inquired as to why the subpoena was served on Colin with such little compliance time. Counsel for Reed did not provide an explanation and simply cited the Massachusetts Rule 45, which permits a subpoena to be served with a 7-day compliance time. But you said it went to counsel of record. Which counsel of record then? Undersigned counsel next relayed the position that the subpoena sought irrelevant information, was overbroad, unduly burdensome, and harassing. When they are talking about harassing here, law nerds, they are talking about within the confines of the rule here. And that is language that all of the discovery rules use, saying if you ask for too much information, you are just trying to make the process part of the punishment. You're trying to make the process incredibly expensive, painful, burdensome, and harassing. So the words used here are part of the code sections when talking about what discovery can and can't be used for. They go on to say, by way of example, undersigned counsel highlighted that on its face, the subpoena request over 4 years of communications between Colin and his parents without making any attempt to narrow those communications by topic. In attempting to reach a compromise on the subpoena's scope, undersigned counsel inquired as to the relevance that Colin has to the wrongful death action, given that he was not at 34 Fairview at the time Reed and Officer O'Keefe arrived outside. Counsel for Reed stated that they were not required to provide any good faith basis for sending the subpoena. Again, what are we doing? Are we really confused as to what their theory of the case is? Also, what's your theory of the case? I don't have to tell you. But what's your theory? Well, I don't have to tell you. First of all, we can all see this from a mile away. But I can understand why Reed's attorneys might be hesitant, because anything they say will invariably be flipped on, well, they said it was this, now this is outside the scope. When attorneys cannot navigate in a good faith way, it really becomes not only anything you can will be used against you, but anything you can will be like, throw it down, flip it, and reverse it, and then used against you. So I can understand where the hesitancy is, because it's wild, but it's like, you tell us why. And they're like, girl, you know why. And they're like, tell us why. Girl, you know why. Ellie says, why is it mentioning his parents? He's an adult. Because they are seeking text messages between him and his parents. That's part of the discovery that is sought, is text between him and his parents. So that's why they're coming in. Also, he was not an adult when this happened, but that's why. Billy Donna said, we want to hear you say it, right? Right? Ella said, can the judge have a hearing with Colin? The judge can have a hearing with Colin's lawyer, and that's what we're going to do next. From yesterday. After we finish all of this, that's what we're going to do next. So they say that the subpoena is overbroad. I agree. I don't disagree. And then they say Reed won't tell us why they want to depose him. They don't have to. Also, I think it's obvious to everyone. I don't think there's any genuine questions about this. I think they, sometimes when you fish, you might get lucky. I think this is a fishing expedition. They don't have to do that. They go on to say that counsel for Reed stated they were not required to provide any good faith basis for sending the subpoena to Colin, and simply that Colin is associated with plaintiff's IIED claim and false narrative allegations. Undersigned counsel relayed that the subpoena was so broad it was impossible to make a counter proposal to Reed without any guidance regarding Colin's relevance. And then they've got the affidavit to support that that's what they told Reed's attorney. The next day, counsel for Reed transmitted come on. Transmit. We're seeking for new ways to say emailed. Oh, okay, then. The next day, counsel for Reed transmitted what they alleged to be a quote-unquote counter-proposal to the original subpoena following the April 28th conference. However, this quote counter-proposal was nothing more than a mirror image of the original subpoena, except for the fact that Reed slightly narrowed the scope of the communications between Colin and his parents, apparently in response to the illustrative example of overbreadth that undersigned counsel gave during the April 28th conference. I mean, it is overbroad. On May 5th, counsel for Reed served 6 additional subpoenas on non-parties: Allie McCabe, Jennifer McCabe, Matthew McCabe, Brian Albert, Nicole Albert, and Brian Higgins. We know, notwithstanding the concerns raised in Colin's responses and objections during the April 28th 9C conference, these additional non-party subpoenas were identical to the objected to subpoena originally served on Colin. I'm not surprised. They say at this point, it became apparent that Reed was not seeking meaningful discovery in an effort to locate relevant information related to the wrongful death case, but was using her subpoena power to obtain over 4 years of unrelated communications in an ongoing effort to harass and retaliate against individuals who had the audacity to give information to the police and testify at trial. That is I do think the subpoenas are overbroad. I think they're reading into it as much. But also, the thing that is so frustrating to me is that at the end of all of this, the case from a lot of these parties against Karen Reed and Aidan Carney are going to unearth all of this discovery about the same time period because they allege things going on and through 2025 and I believe into 2026. All of this is going to come up. We're just not there yet. So I understand why they're just like, this is overbroad for this request. But at the end of the day, this is all going to happen in the next case. And that's, I think, where I get stuck on being frustrated, because we can all see that this is happening down the road with all of the other litigation. And so it's so frustrating to just continue to fight in the weirdest ways. Either way, it is an overbroad subpoena. They have every right to say, yes, the subpoena should be narrowed, but each individual witness has the right to argue that the subpoena should be narrowed. And it should be narrowed in this litigation. It's going to be embiggened in the other litigation, which is why there have been these back and forths about whether all this litigation should be combined or not. Okay. Continuing on, they say that this was not seeking meaningful discovery and that it was a retaliation because of the audacity. Thus, since Reed's team refused to do so, it became incumbent on counsel for the Alberts, the McCabe's, and Mr. Higgins to propose reasonable topics of communications that they believed to be within the scope of the issue presented in this case. Oh, I imagine that some of the requests for discovery are going to be met with that things have been rehomed. Also, Higgins. Not legal advice, just lawyer thoughts. Y'all don't want the same lawyer. I'm going to say it every single time we talk about these cases. Y'all don't want the same lawyer. This is not a conflict that you should be waiving, even if you can. Yeah. I can understand the McCabe's and the Alberts. I can understand like the Alberts as a family. I could understand the Alberts having a lawyer, the McCabe's having a lawyer, and then Higgins having a lawyer. But Higgins, you know what you don't have that the other witnesses have between each other? A, blood and marriage, but B, there's a lot of spousal privilege that's going to go on with some of these witnesses that you're not a party to. So where these Venn diagrams overlap, yours isn't really overlapping all that much. The Albert and McCabe Venn diagrams are overlapping a whole lot. Yours, not so much. Separate lawyer. Separate lawyer. Miss C says, do you think they'll eventually turn on each other? I think that someone will have things pointed more at them. I suspect that person's going to be Higgins. Just how I see it. I can understand for the Alberts and the McCabe's why they would want to have Higgins have the same lawyer as all of them. I can't understand why in the world Higgins would think that that's a good idea. It is a terrible fucking idea. It's a terrible idea. It is a strategically good idea for the Alberts and the McCabe's. It is a strategically terrible idea for Higgins. This is a terrible plan. Yep, terrible plan. So, we'll see. We'll see what happens. Just my thoughts. They go on to say that Colin Albert joins the United States Army. All right. Muzzarlina? Are they trying to save money? Possibly, but it's not going to necessarily work out that way. But I'm sure that's part of the thought is that they're trying to save money. I'm just telling you what my gut says on this. Bad idea. That's just how I see it at the moment. They know more about this case than we do. But I think that's a real bad idea as they go through this civil litigation. But we'll see. They say Colin Albert joins the United States Army. On May 19th, 2026, Colin informed counsel that he would likely be joining the U.S. Army, and that if so, he would be forced to leave Massachusetts for initial and basic training beginning June 2nd. I can't believe that that's how that conversation went. I do not believe you. I just don't believe you. I don't believe that Colin said, I'm kind of thinking about it, but I know that I'd be leaving June 2nd. I do not trust that representation because it does not logically follow. He thinks he's going to join the Army, and if so, he would have to leave for initial and basic training June 2nd. That seems odd to me. They say on May 20th, Colin confirmed that such would be the case and that his situation would limit his access to phone or email communication. That I believe. The same day, counsel for Colin notified counsel for Miss Reed of Colin's sudden scheduling conflicts, proposing 2 dates for Colin's depositions, May 28th and 29th. Those were within the same compliance period of notice given to Colin by Reed's original April 21st subpoena. So now we're working within the original subpoena. So wait a second. You're telling me that on May 20th, you're still working within the original compliance of the April subpoena? So you agree that the subpoena still stands? They go on to say, Colin originally requested that the circumstance of his unavailability remain private given the profound levels of harassment and intimidation that he has previously been subject to from Reed. I can't imagine that you would see that fuckery spill out at like boot camp. Or that anybody would give a shit. I would imagine they're too tired to bother. Just my thoughts. I don't know. But they wanted to keep the circumstances of his unavailability private, given the profound levels of harassment and intimidation that he has previously been subjected to from Reed, non-party Aidan Carney, and their following, including dozens of instances of third parties showing up at his home, workplace, and school. Don't do that. To protect his best interest and for safety, Colin's counsel provided unqualified representations of his unavailability without mentioning he was joining the Army, instead stating that it was work-related, and this was something Colin's counsel had just learned as well. For all of the writing in this, that sentence is so fucking awkward. Footnote 1. Colin's concerns about public disclosure were well-founded because notwithstanding these reasonable efforts, it became public within hours of Colin's swearing-in ceremony that Colin had joined the military. How? Did someone post a picture of it? How many people are at a swearing-in ceremony? Okay. Colin's concerns about public disclosure were well-founded because notwithstanding these reasonable efforts, it became public within hours of Colin's swearing-in ceremony that Colin had joined the military. Indeed, non-party Aidan Carney published a video disclosing Colin's decision to join the Army and publicly announcing that Colin was a big fat pussy. And that he joined the Army to avoid going to jail. I mean, I don't think you avoid going to jail by joining the Army. Also, can we stop disparaging pussies? I do not acquiesce to this pussy slander. I'm not here for it. Also, great band name. Great band name. Can we add that to the list? Can we add pussy slander to the list of band names? Leave the pussies alone. However, it is not lost on me that I know, right? We need like pussy slander opening up for Joan Jett and then Evanescence. I'm here for it. Bring back Lilith Fair. Let's go. I'm ready. But also, counsel are saying that Colin Albert has been subjected to horrors untold on the internet, and the statement that they choose to highlight is that Colin was called a big fat pussy. Okay. If you're telling me that the harassment is so severe, is there nothing else? We've seen the court filings relating to Proctor's text messages. This is it? This isn't even a Call of Duty lobby. What is this? Okay. Continuing on. I love a sassy legal document. I think that when we are looking at talking about harassment, threats, intimidation, harassment so severe it causes someone to drop out of school, I'm not arguing that those things can't happen and don't happen and can be awful and can be damaging to people's mental health. But when we are saying that what he is being subjected to is at that level, and then the citation that you bring is this, it makes me question if there is more there. And also, if everything's the worst thing that's ever happened, then nothing is. So, it annoys me. Continuing on. They say that in the same May 2026 email, counsel for Colin relayed a proposed scope of potentially relevant communications to the wrongful death action. Notice we're now narrowing it down to this action. Right. We're narrowing it down to this action because we know that there's going to be a lot more discovery in the defamation action. Like this is a pause. It goes on to say that their narrowed scope of communications for the wrongful death action included communications from January 28th, 2022 to present between Colin, Michael Proctor, Yuri Buchanan, and any other law enforcement official associated with the investigation of the criminal trials of Reed. You don't think people are back channeling though? If they have access, whatever. Emily, you're not here to argue this motion. 2, all communications between Colin and any other individual on or around January 28th, 2022 pertaining to the circumstances surrounding the death of Officer O'Keefe and the investigation. I think it would also need to expand to what they were doing, where they were, et cetera, et cetera, et cetera. So I think that is overly narrow, but I've said that earlier. They go on to say that counsel also relayed in good faith that Colin had undertaken reasonable efforts in the prior weeks to locate communications responsive to all those categories, but with the exception of a singular text exchange, no other responsive communications exist. Footnote 2. The efforts undertaken to locate these communications are described in detail in the affidavit of Colin Albert. Oh, so he searched it and found nothing. That affidavit better be attached. I don't know if it is. I guess we'll find out. They go on to say counsel stated that it believed Reed was in possession of that text message. Indeed, she references it in the motion itself. That's the message between Colin and Allie. But that Colin would be willing to produce it to the extent that undertaken or understanding was mistaken. They don't want a screenshot of it, though. What they were asking for is that text message with metadata. So if you're just going to give them another screenshot of it, I don't think that's helpful. Despite giving Colin the exact same amount of notice for his original deposition, counsel for Reed declined to accept Colin's offer to be deposed on May 28th or 29th. Instead, counsel for Reed stated that the one lawyer designated to take Colin's deposition, attorney Charles Waters, Chaz, was out of state on those dates. The thing for me that's difficult here is that the filing by Waters states that Colin Albert's attorney knew that prior to plaintiff's counsel subpoenaing Colin Albert. That timing is difficult for me. If that timing was not so, if this was scheduled and Colin Albert's attorney didn't know that those were dates Waters was unavailable, I would feel differently about it. But the fact that Colin's attorney knew that Waters was unavailable those dates prior to plaintiffs miraculously knowing that he was available for deposition, those things together raise questions for me. They go on to say Reed's counsel did not describe the circumstances of the designated lawyer's unavailability or explain why any of the other 9 lawyers representing Miss Reed could not take Colin's deposition. Chat, just let me know what you think would have happened if they responded, fine, Alan Jackson's available, he'll come take Colin's deposition. What do you think the response would have been then? Reed never identified whether attorneys Rosenberg, Seligson, or Jackson, keep reading, Emily, who extensively questioned Colin during Reed's first criminal trial, were unavailable. On May 21st, 2026, Colin's counsel also informed plaintiff regarding Colin's sudden availability issues. Oh, so there was a phone call. Why are we burying this in the motion if it's not a thing? Why are we so vaguely, they just knew that he was unavailable? You told them. Why are we just going so far and away to sidestep the fact that you told them? If it's not shady, why not just say it? Instead of burying it on page 10. On May 21st, Colin's counsel informed plaintiff's counsel that Colin had sudden availability issues. With no deposition scheduled prior to Colin's departure on May 22nd, plaintiff served a subpoena on Colin through counsel. Oh, right, because Colin's counsel was like, yeah, we'll accept his subpoena. Commanding his attendance at a deposition on May 28th, see Exhibit 7. Bound by the subpoena on May 28th, Mr. Albert was deposed, where he testified truthfully under oath regarding the events of January 29th, 2022, in addition to other issues. It just raises a question for me if they are using this deposition to then go to the court and say, hey, he was already deposed. Reed's attorneys can use that one. Tough. Reed's attorneys can use the other deposition. It seems that there is strategy here. And the strategy doesn't seem to be, oh, he's suddenly unavailable. It seems like more than that to me. Maybe I'm reading more into it. Maybe I'm not. Seems sus. Bound by the subpoena, he was deposed on May 28th. Counsel for plaintiffs, as well as counsel for defendant C.F. McCarthy's, questioned Colin. Counsel for defendant words, Emily. Counsel for defendant Waterfar. It's the Waterfar now. Today it's the Waterfar. The Waterfall Bar and Grill was in attendance via Zoom and did not ask any question. None of the 10 lawyers for Miss Reed chose to attend Colin's deposition, even though, upon the undersigned's information and belief, another witness deposition was previously scheduled for that day but canceled. Further, the deposition occurred within the same building as Sheehan Finney's office. So it was in the building that Rosenberg's office is in. Here's the thing. Now we get into legal strategy. My question is, what would the arguments be if Reed's lawyer, who was not prepared to take the deposition, so Chaz is apparently the depo lawyer for Colin Albert. Other lawyers are working on other things. There are 4 separate civil litigations here, in addition to what other cases they have. So if another lawyer had attended and sat in, what would be the argument? Your Honor, they appeared. They had an opportunity to cross-examine him. Because if they're not the ones subpoenaing the deposition, they're not doing direct examination. It's not their deposition. So would the argument then be, well, they had an opportunity, they don't get another deposition? Here's where the issue is. So if they showed up, then the argument is they had an opportunity to depose him and they didn't. So he shouldn't be required to sit for another one. Yeah, so I'm not surprised that when they said we're unavailable this day for the deposition, that they didn't show up. Exactly. And Dana said it limits their scope of questions. Right. it limits what they can ask about to what the deposing party plaintiffs asked about. So I can see where the fight would be if they had shown up saying, no, they shouldn't get a second deposition. He's unavailable. I can absolutely see where that fight would happen next. None of the 10 lawyers from Ms. Reed chose to attend, even though it was in the same office as I think that's Rosenberg's firm. June 3rd status conference. We might have to go back and watch this status conference. We'll see what time we get to today. We already watched this once, but I might be curious. Austin said, Emily, that's not typically true during a depo. Cross is not normally limited. I can imagine that they would be limited, if not in scope. Austin, I appreciate you clarifying. If not in scope, by time. And I think that they could run into limitations of time. Maybe not. And maybe the court would be chill. I don't know if the court would be chill. I can just see where the argument would be set up if they showed up and said, no, but we're not doing this deposition today because this is not the lawyer prepared for this depo, that would come back and bite them. And then if that lawyer said, I'll ask questions now, but we still want our second depo, that might become a fight as well. So I can see where those fights might be. And then it would be, well, you had your shot at it, too bad. So I can see those fights happening. On June 3rd, 2026, during a June 3rd, 2026 status conference, and I'll link where we watched that together below. It was not on June 3rd. We watched it subsequently, but we did watch that status conference. During a June 3rd, 2026 status conference in this matter, counsel for Reed, attorney Rosenberg, accused the undersigned, as well as Colin, Brian, and Nicole Albert, the McCabe's, and Mr. Higgins of playing games. Why ever would they say that? Accused them of playing games with the wrongful death discovery schedule. At no point prior to making the accusation to the court that these non-parties were quote unquote playing games did Reed's counsel undertake any effort to inquire about the schedules of these non-parties or their counsel so that all parties could come to a mutually agreed upon deposition date. Instead, it appears that this courtesy was only given to other witnesses in this case. Look, at the June 3rd hearing, the court was lighting into Rosenberg about why they weren't getting their shit together and getting these depositions done. And to the best of my memory, Rosenberg was like, well, Your Honor, part of the problem is that yesterday at like 9:30 or 10:30 p.m., we got an email that all 6 of these other depositions are going to have to be rescheduled. So part of the problem is we keep running into this, that we scheduled all these depos and then all 6 of them are like, now we need to reschedule. So if I am remembering correctly, the court was peppering Reed's attorneys like, why aren't you getting these depos done? And he was like, this is why. Because this shit keeps happening. And yesterday at 9:30, 10:30 p.m., I got this email. So it keeps happening, Your Honor. Chat's like, if not games, why games shaped? I'm waiting for Rosenberg to come in and be like, Your Honor, I'm sorry. We rolled efficiency and came up with a 3 in this case. Our bad. Moreover, they say, oh, they're still mad about this. Moreover, during the same June 3rd status conference, counsel for Reed previewed this motion outside the presence of Colin's counsel, and in doing so, proffered to this court that, quote, Colin Albert refused to appear for deposition and refused to produce documents. And then they link it to the trial channel for that YouTube video. Oh, good, there's timestamps. Maybe we will go watch it. As this opposition and supporting documents clearly demonstrate, that proposition made in open court and to a live streamed audience of hundreds Girl, we watched that hearing. That hearing was not live streamed to an audience of hundreds. Cute though, because we covered that hearing. To a live stream audience of hundreds was wholly and demonstrably untrue. Colin never refused to appear for deposition. Miss Reed's counsel canceled his deposition. Then, Colin sat for deposition in this case on May 28th, 2026, and Reed's counsel refused to appear. The patent misrepresentations regarding Colin refusing to appear for a deposition sparked immediate online attacks and defamation against Colin. Following that misrepresentation, Colin, as well as other non-parties, were harassed, defamed, and ridiculed by dozens on various social media platforms, falsely claiming that Colin refused to appear for the deposition. Are you calling Colin Albert? This can't be accurately. This can't be what is meant by this sentence. Are you saying that dozens of people online saying that Colin refused to appear for deposition is harassment and defamation? That can't be what is meant here. That people reporting what was said in court in that way, that's not what you mean, right? Okay. They say that dozens on social media platforms falsely claim that Colin refused to appear for the deposition. This was entirely predictable. That hearing was so fucking confusing about if there was a deposition, if there was not a deposition, when there was a deposition. Yeah, it was confusing. There were questions, but people reporting that Colin didn't appear for a deposition can't be what you mean. Attempts to meet and confer to redress the June 3rd misrepresentations. Oh boy. During the court's motion hearing in the defamation action and on June 4th, underside counsel sought to address the misrepresentations with the court. After that hearing, the undersigned initiated a meet and confer on this issue with Reed's counsel, Attorney Seligson. Rosenberg was the one talking in court that day, though. I mean, I understand why you might want to talk to Attorney Seligson. I get it. Chat was like, I'd call up Attorney Seligson just to say, hey, hello, how are you? I get it. But Seligson wasn't the one talking in court. So counsel initiated a meet and confer with Attorney Seligson about what the fuck your colleague Rosenberg said, explaining to Reed's counsel that the misrepresentation was serious, clearly contradictory to the record, and sparked substantial public attacks on Colin. Are the substantial public attacks that dozens of people online said he didn't go to a deposition? The following day, counsel for Colin reached out for an explanation and willingness to see if Attorney Rosenberg was willing to retract or clarify his statements. Hold on. Chat, we're on page 11. Give me a second. This was signed June 9th. You're telling me that in this motion, signed on June 9th, you are still complaining that the record has not been clarified when, in fact, counsel filed a motion to clarify the record and seemingly said that they would? But you're still... Hold on. I want to go look at and see what date docket 111 was signed. I have two other issues with this, but we're doing this first. Docket 111. You demanded that he correct the record. And on June 8th, he filed docket 111. This motion wasn't completed until June 9th. Why are we litigating this? It's just giving you mad, bro. Because clearly the answer is yes. And the letter was written June 6th and filed with the court June 8th, which means counsel had it on June 6th. It was sent to counsel of record via email on June 6th. Okay. Continuing on. We're just relitigating everything. I just was curious about the date. And yes, all of you are asking, how does Colin know what people are saying online on June 3rd if he's at basic training on June 2nd? Fair. Billy Donna's said, and stricken on the 11th. I think it was struck on the 11th or the 12th. It might have been the 12th that it was stricken from the record. But counsel still had it, and so did the court. But yeah, how does Colin know what people are saying about him online on June 3rd if he's already gone to boot camp? And some of you are saying it's not boot camp. Don't worry, we'll get there. I'm going with what's in this filing. We're gonna let it unveil filing by filing. So they called Seligson to see if they could have a meeting with Rosenberg to clarify the record. So what day are we on? June 5th, maybe? Because they say the court's motion hearing was on June 3rd. And then on June 4th, they reached out to counsel. And then the following day, so now June 5th, the following day, counsel for Colin Albert reached out for an explanation and a willingness to see if Attorney Rosenberg was willing to retract or clarify his statements. Rosenberg indicated that he would evaluate the wording he used during the June 3rd hearing and let Colin's counsel know whether his statements needed clarification. Then on Sunday, June 5th, he filed unilaterally with the court a letter that did not correct the record, but rather continued to make misrepresentations.
Your Honor, he doubled down. I said correct the record, and he said, but I said what I said. Your Honor, we don't agree that what he said is accurate, because it was rescheduled or canceled, depending on the sentence.
Emily, how is any of this relevant to Colin Albert's deposition? Yeah, no, most of that's not. Most of that's not. They're just mad. They're all mad. Everybody's mad at each other. Everybody's all mad. We demand you correct the record. Fine. I said what I said. But he didn't produce documents, which is different than not showing up to a deposition. Not showing up to a deposition can leave the impression, we'll just put it on the docket for today. Law Nerds get a snack. Just put it on the docket for today. We'll go back and watch that part of the June 3rd hearing together again with new information. See what we can glean. Not failing to appear for a deposition gives the impression that a deposition was set. Everybody's sitting in a conference room with their coffee and they're looking at the door with anticipation and no one walks through. It's giving runaway bride. The failure to provide documents and refusal to comply with a subpoena are different. Okay. We can go back and look. Does it matter all that much? What matters is if he's still under subpoena. That's what honestly matters here. That's what matters the most. Argument. Reed's motion fails to cite a single case, rule, or statute to support its arguments. Instead, the motion relies on misleading and fabricated claims and is used as a mechanism to continue to harass Colin by impugning his character. They say that the deposition subpoena is no longer valid. The subpoena must command the witness to appear at a specified time and place. Thus, once the date passes without the deposition occurring, there is no longer an operative command to appear at a future deposition. If counsels agree, this can't be the rule, right? If counsels agree that a deposition subpoena will be continued, it is not the case that that deposition is then void. You can imagine the gamification in the system. If lawyers were like, yeah, we agree to continue the date, and then they let the deposition date pass and go, subpoena us again, we refuse to appear, your subpoena is no longer valid. That is not how that rule would operate. They go on to say that the plain language of the rule makes clear that a non-party subpoena is not a continuing obligation unless it is reissued or amended to impose a new command. Amended. If you all agreed by email to continue it, it's amended. They say the original subpoena is functionally exhausted once the date contained therein lapses. Here, Reed's counsel never once inquired as to Colin's availability before serving him a deposition subpoena. Despite this, Colin was ready, willing, and able to attend the April 29th deposition. We're just rehashing what they said earlier. They say Reed's counsel unilaterally canceled the April 29th deposition. There's disagreement over that. They say they were rescheduling it. In canceling the deposition, Reed's counsel cited the parties' ongoing dispute regarding the scope of the document subpoena, but the motion ignores the fact that Reed could have taken Colin's deposition on April 29th and continued it to a later date pending the disposition of that dispute. Reed's counsel chose not to do so and failed to reissue a deposition subpoena for a different date. Plaintiff's counsel thereafter issued their own subpoena commanding Colin to appear at deposition. Colin sat for the deposition on May 28th. The only party to this action that did not appear was Reed. Reed's counsel cites no authority justifying this conduct, much less any authority that would support an order commanding Colin to appear at a deposition. They say that the subpoena is overbroad. I don't disagree with the overbroadness. They're citing the different sections. How are we at 14 pages on an opposition? Because we are now just rehashing what they said above. Let's see. The court should deny the motion for the independent reason that Reed's counsel violated Mass Rules of Professional Conduct 3.3a, because they say for years, Colin and others have been subject to outrageous abuse for no reason other than his willingness to cooperate with law enforcement and the investigation into the death of Officer John O'Keefe. That abuse has included defamation and misinformation and has been publicized by Reed and her attorneys in a judicial forum. Much like this motion is publicizing the dispute in a judicial forum. Further misrepresentations by counsel in a case such as this will have a profound impact on various non-party witnesses, including Colin. Not if he's not online, it won't. Because I can't imagine that his drill instructor is going to yell at him about that. So, unless they didn't know he was involved in multiple lawsuits and then he might get yelled at about this, but not because of anything said in court. They say that further misrepresentations by counsel in this case will have a profound impact on various non-party witnesses, including Colin, because they are immediately relied upon and used by online purveyors of lies. Okay, that's a turn of phrase I'm not mad at. I'm not mad at that turn of phrase. I don't know if I disagree. I don't know if I agree. I may disagree, but it's a great turn of phrase. I'm not mad about that. Immediately relied upon and used by online purveyors of lies who give this line to Sarah Boone. She would love it. Sarah Boone is going to add this to her soliloquy about the online sphere that has blood on their hands for talking about her case. Like, add this to Sarah Boone's soliloquy. Oh boy. It is for this reason that the court should treat such misrepresentations, especially those that are endlessly parroted against the various non-party witnesses, very seriously. As detailed below, counsel's collegial efforts. Girl. Seriously? As detailed below, counsel's collegial efforts to convey this concern to Reed's counsel was met by indignation, followed by the submission of a convoluted and misleading letter to the court that only compounded the harm. Just because someone says bless your heart doesn't mean it's collegial. You don't have to yell to not be collegial. Reed's counsel's was met by indignation, followed by the submission of a convoluted and misleading letter to the court that only compounded the harm. Here, the misrepresentations by Reed's counsel to this court on June 3rd violated rules of professional conduct. First, the statement was false. Colin did not refuse to appear for his deposition. The email correspondence attached here too, don't worry, we're going there next. Attached here too, confirms that Reed's team canceled the deposition and never rescheduled it. Second, the falsity was known to Reed's counsel at the time he made the statement. Colin did not refuse to appear for Reed's deposition. Reed's counsel canceled the deposition just 6 days after the subpoena was served. I don't think that word means what you think it means. Colin was available and prepared to appear in response to Reed's deposition subpoena on the noticed date. Third, the statement was material. Now he's going through the rules of professional conduct. Your Honor, sanctions! They're asking for this motion to be denied as a sanction. So they're asking the court to not compel the deposition and document production as a sanction for the violation that they perceive on June 3rd. That's what they are asking for. So that's why they are marching through the elements of a violation of rules of professional conduct. After this issue was initially raised following the June 4th hearing in the defamation case, I don't think that hearing was streamed, recorded, or otherwise memorialized for us to go look at, but there was a June 4th hearing in the defamation case regarding protective orders. So, Chloe UK said, can this be a sanction towards Karen Reed's attorneys? That's what they're asking for. They are asking, Colin Albert's attorney is asking the court to sanction Reed's attorney for a violation of the rules of professional conduct by denying this motion. They are asking that the motion be denied as a sanction. That's one of their requests here. After this issue was initially raised following the June 4th hearing in the defamation case, counsel for Colin tried to confer with Reed's counsel regarding this issue to see if the parties, why are we doing this in another paragraph? You've said this in like 4 different places in this motion. No wonder we're on page 17. Y'all are repeating yourself more than I do. Counsel for Colin tried to confer with Reed's counsel regarding this issue to see if the parties could reach an agreement on a corrective filing. That might be why they met with Seligson then, if he was at the hearing on June 4th. But that's not even how they represented it earlier. They represented it as if they reached out for Seligson. Okay, whatever. And now it's after the court hearing. Fine. There's new information every time they talk about this, which also makes it hard for me to follow. Did you reach out to Seligson? Did you talk to him after the... Following the June 4th hearing in the defamation case, counsel for Colin tried to confer with Reed's counsel, regarding the issue and to see if the parties could reach an agreement on a corrective filing. Indeed, it was counsel's explanation that if Reed's counsel's misstatement had been inadvertent or careless, Reed's counsel would appreciate the harm that the statement was likely to cause and voluntarily correct it. Instead, so that's what they anticipated. Well, you can't expect that other lawyers are going to see this situation the way that you do. So your expectation is misplaced. It was counsel's expectation that Reed's counsel would just be like, oh no, and then they would correct the record and appreciate the harm that they had caused. Instead, Reed's counsel responded with personal criticism towards opposing counsel and continued his assertions that the same was playing games to avoid Colin's deposition. See Exhibit 8. Oh boy. Let's go immediately to Exhibit 8. While Reed's counsel ultimately agreed that his statement that Colin refused to appear for deposition was somewhat inartful in context, he stated a willingness to clarify the record. Connie, this is a 10 out of 10 comment. Connie in the chat said this motion is breathtakingly repetitive. Yes. 10 out of 10. Instead, despite counsel's effort to further meet and confer, they're just continuing to relitigate. But Your Honor, counsel said he refused to appear. He didn't refuse to appear. He refused to give the documents, but he said he would appear. And then they didn't want him to appear because they thought it would be better to just do the deposition after he had the documents. Because if you did the deposition before you had the documents and then they got the deposition, then they got the documents and then they wanted another deposition, what would these attorneys say then? But Your Honor, they've already had a chance to depose him and he's unavailable. Exactly. That's exactly what would happen. But all right. They continue on this point. Instead of offering a plain, candid, and professional acknowledgement that his public accusation that Colin was incorrect, Reed's counsel's letter took additional swipes at Colin by confusingly suggesting that he had been referring to broad discovery disputes. This did not remedy the harm, but compounded it. The plain meaning of the word refused to appear communicated to the court and the public that Colin affirmatively declined to attend his deposition. So y'all agreed to reschedule it? This is how any reasonable listener would interpret those words. This is how members of the public understood the statement. Who cares? Who cares what the public thinks about whether or not Colin went to a deposition? Who fucking cares? It seems the confusion here is we have dual depositions. We have dueling depots. Worse than dueling pianos, in my opinion. But who cares? You have now corrected the record. It was rescheduled, but now you keep saying it was canceled when it seems that maybe it was rescheduled. So what is it? Was it canceled or was it rescheduled? Because it's getting confusing. They go on to say that Reed's counsel's post hoc explanation that he was actually referring to a series of future scheduling and document production disputes only underscores that his original statement was misleading. A dispute over document production or future scheduling in no way means that Colin refused to appear. The harm flowing from the misrepresentation has been substantial. Tell me more. Colin has been subjected to a campaign of online harassment and intimidation that was sparked by Reed's counsel's false statements in open court. I thought he was at basic training. You said he shipped out June 2nd. This hearing happened after that. Is he scrolling TikTok in between burpees? What is he doing? Okay. A dispute over document production or future scheduling in no way means Colin refused to appear. The harm flowing from this representation has been substantial. Colin has been subject to a campaign of online harassment and intimidation that was sparked directly by Reed's counsel's false statements in open court. Indeed, in the hours and days that followed the June 3rd status conference, disturbing comments were publicly made in direct response to Attorney Rosenberg's representations, including that Colin made the decision to serve his country in order to flee his deposition in the case, and that such decision meant Colin, quote, can kill legally. Okay. Other comments made immediately following the status conference included that Colin was complicit in murder, accused Colin of dodging a deposition with Olympic-level agility. Counsel? It's difficult for me to follow that the beginning of this paragraph says that the harm flowing from the misrepresentation has been substantial, that he has been subject to a campaign of online harassment and intimidation. And then you follow that up by saying that the internet said that he dodged his deposition with Olympic-level agility. If that is a comment that is causing this much distress, boot camp might be a might be a challenge. And that's not me saying that online harassment is okay. Online harassment is not okay. But can you get to where the harassment is and maybe leave the online commentary that you take issue with to the side of that? Because this is online commentary. Okay, I guess we'll continue to see if they Exhibit 9, compilation of online harassment tied to the June 3rd misrepresentation. Okay. It seems to me, if you are starting out a paragraph, and maybe this is just me, but it seems to me if you're starting out a paragraph that the harm has been substantial, you would kind of put the most substantial, shocking, and appalling statements in the following sentences. Things that would like shock the conscience. You would think that those would follow next. So I was kind of anticipating that. It seems like a sudden choice to join the military. Maybe that was always the choice. Maybe he was in his ROTC program in college. Then again, if you're in your like ROTC program in college, don't you go in as an officer? Isn't that different? Maybe this was always the plan. However, by the way, joining the military, unavailable. I can understand why people might characterize that differently. Continuing on. Even after Colin's counsel put Reed on notice of her counsel's Rule 3.3a violation and attempt to meet and confer regarding a potential resolution, Reed's counsel nevertheless continued to project the false narrative that Colin refused to appear for deposition. I don't understand why this is going on and on and on and on for pages. It's okay. Even after they told Reed's attorney that they violated the rules of professional conduct and we want to meet and refer regarding your violation of the rules of professional conduct, Reed's counsel continued to project the false narrative that Colin refused to appear for his deposition. For example, on June 5th, 2026, during Reed's recent media campaign, I guess we know why they're bringing this up with the court after we saw the last court hearing where the court was pissed about it. Attorney Alan Jackson appeared on podcaster Billy Bush's YouTube show. I love that people don't even know what to call the internet anymore. It's like the YouTube show. Okay. Wherein he discussed issues pertaining to Colin Albert's deposition. On that show, Attorney Jackson stated that Colin has not yet been deposed or has not been deposed yet, accusing the undersigned of engaging in shenanigans and playing a few games and alluding that the Reed team intended to reissue a deposition subpoena on Colin, notwithstanding his recent enlistment in the U.S. Army. So the issue is that Colin Albert has been deposed, but not by Reed's team, and you would like him to parse the two? Is that the criticism? Or is it the shenanigans? But also, some of the stuff it's giving shenanigan. The timing of everything is giving a bit of shenanigan. I would love it if y'all want to explain to me how it's not shenanigans. Because the way it seems is that y'all knew that Reed's attorneys were unavailable, and then plaintiff mysteriously decided that now was the time that they needed to do Colin Albert's deposition and scheduled it for the days that they knew exactly that the prepared attorney was unavailable. That it's giving shenanigan. But if that's not what happened, it sure hasn't been cleared up in this motion. For the foregoing reasons, the court should exercise its inherent authority and deny the motion because of Reed's counsel's rule violation. Notice the argument there. What didn't they say? They didn't say the motion should be denied because the subpoena is no longer valid. They said that the motion should be denied because Reed's attorneys said that Colin Albert skipped his depo. Conclusion. Had Reed's counsel engaged in good faith to reach reasonable consensus regarding the subpoena, this motion practice would have been unnecessary. They refused to do so. Instead, they offered Colin hollow compromises, which were indeed not compromises at all, refused to coordinate their schedules to accommodate his recent and commendable career change. You're missing the word sudden. And subsequently made entirely false misrepresentations in open court. Contrary to Reed's accusations, the only one engaged in gamesmanship here appears to be her. For the foregoing reasons, this motion should be denied in its entirety, and the court should grant any further relief deemed just and proper based on the longstanding principle of, I know you are verse, but what am I? Yep. I know you are verse, but what am I? Is what they're citing here. Nuh-uh, Your Honor. Nuh-uh. Yes, rubber versus glue is a much more succinct way of saying the exact same thing. Exactly, honk banana no. Yeah, rubber versus glue. And pot versus kettle. I would also go with pot versus kettle as supporting documentation here. Your Honor. We're not engaging in gamesmanship. They're engaging in gamesmanship. Let's go look at the exhibits, shall we? We are not going through all of the exhibitees. This is an affidavit of Kieran Murphy in support. Let's see. On April 28th, I participated in a conference pursuant to Rule 9C regarding the subpoena. Also in attendance were my colleagues, James Tuxbury, Christopher Matai, as well as counsel for Reed, Aaron Rosenberg. In that conference, well, why isn't Tuxbury the one filing this? Inquired with Rosenberg regarding why he... So this is hearsay then. If we're asking... whatever. In that conference, Tuxbury inquired with Rosenberg regarding why the subpoena was served with such a limited time compliance. In particular, the April 21st subpoena required that Colin produce documents by April 27th and sit for the deposition on the 29th. Reed's counsel did not provide an explanation and merely cited the rule permitting subpoenas to be served with a 7-day compliance time. Counsel then discussed the responses. In particular, we discussed Colin's position that the documents requests were overbroad. Tuxbury highlighted the document requests as written, sought over 4 years of communications. Okay, this is all what we've already seen elsewhere in the motion. Exhibit 1 is a half of a photocopy. This is the whole document, chat. This is the entirety of the document. This is the whole thing. Wait. You've got to be fucking kidding me. This is Colin Albert's declaration submitted in support. You've got to be kidding me. You've got to be kidding me.
Don't be suspicious. Don't be suspicious. Don't be suspicious. Don't be suspicious.
They submitted this to the court. This is the entirety of the document, chat. I am not zoomed. I am not zoomed. Hold on. Let me zoom out to show you my not zoomed, because we are not zoomed. This is in fact the entirety of the document. Also, the first page starts at 2, not 1. On the evening at Uncle's house, Albert Jr.'s birthday, doesn't start at 1, starts at 2. 3, I arrived at 34. 4, around 11, cousin, Allie McCabe, Fairview. 5, she texted back, people first. 6, around 12, picked me up from 34. Plaintiffs and attorney, defendant C.F. McCarthy's, represents defendant, but did not ask me any questions. And then it goes from point 6 to 16. As for the DO, asked for shortly after, me try to find certain. First, I checked communications on my subpoena. I confirmed for Michael Proctor phone, so I don't have about anything signature page. What in the actual fuck is this? Your Honor, the other side continues to not respond to things professionally. I don't even know how this gets filed. All the paralegals in the chat just fell the fuck over at work. This was filed June 12th. Today is June 18th. Some of you are saying they fixed it today. Today is June 18th. How does this even happen? All right. Exhibit 2 is a photocopy from 1965 of a screenshot of a text message. January 28th, 2022 at 11:54 p.m. You can get me now if easier. Okay, I'm driving people home now. Word, get me after. KK, here. Okay, at 12:10 a.m. And then no text until February 20th, 2022. I thought they were besties. No text until February 22nd. And then the response is on a Zoom. You're missing some information. Exhibit 3. This is the report from October 17th, 2023 from Tully and Buchanan that they tracked down an individual who they purport to be the person who gave the statement to Yannetti. Notice this is from 2023. We're not going through the entirety of that because there were emails, and I wanted to go through those. This top email is from April 27th. I'm just going to see if there's a thread that's going on under this because oftentimes I end up finding out too late that there is in fact a thread. April 27th at 11:24 a.m. Yes. Started from the bottom. Now we're here. All right. I do think some of the terrible copying is perhaps the court's online filing system, but I am not 100% sure. I do not know what the original documents look like. There are a multitude of factors that could be involved here. Aaron, attached, please find non-party Colin Albert's responses and objections to subpoenas that was served on him April 21st, 2026. Regards, Kieran. That's at this is to Aaron Rosenberg. This is April 27th at 11:27 a.m. So they said, hey, you need to respond to the documents by April 27th. And on April 27th, they said, we're not responding. We're sending you our objections. Charles Water responds. Chaz responds on April 27th at 12:57 p.m. Kieran, I'm taking this deposition. Please advise a few times in the next day or two when you or your team are available for a 9C conference to narrow this dispute. Under the circumstances, it makes sense to take Colin Albert's deposition after all responsive documents are produced. Chaz. Tuxbury responds at 2:54 p.m. Further, to clarify, are you canceling the deposition scheduled for Wednesday? Thanks, Jim. Response at 4:21 p.m. from Aaron Rosenberg. Jim, yes, we can discuss both topics tomorrow. Confirmed that Wednesday's deposition will be rescheduled to a different date. See you virtually tomorrow. Okay. Rescheduling. Schedule A, and this is all the things that were requested. We saw some of this yesterday. I will post this in the lounge if any of you want to read through it more fulsomely. They are including the subpoena ducis tecum, the SDT, to Jen McCabe, I think to support that these were the same, because that's what they argued. Oh, you're really all of them? Fine. The one for Allie McCabe. No wonder this is so many pages. And then the one for Brian Higgins. Note they're all served to the same lawyer because they all have the same lawyer. Next, I'm just scrolling past these. Next is to Nicole Albert, same lawyer. We know they all have the same lawyer. Next is the one to Brian Albert. Fine. They're like, we're going to show you all of them, Your Honor. Okay. Matt McCabe. Is that it? Are we done with these? Exhibit 7. Subpoena for audio-visual deposition testimony. This is to Colin Albert. Date, time, May 29th. This is the subpoena from plaintiffs. So, subpoena for audio-visual deposition. You are commanded to appear at location May 28th, 10 a.m. And then that is notarized by Mark Diller, who is a notary public. So Mark Diller has notified the subpoena that his associate who works at Diller Law Group or Diller Law is serving. Okay. Notice of audio-visual deposition to all counsel of record. And this was sent to, again, all the attorneys of record from Mark Diller. Exhibit 8, emails. Let's see if we get to the bottom of the chain of emails here, since I did not put them in order, it seems. The first email here is from May 22nd at 4:03 p.m. Let's see what the top one is. Sorry to scroll back and forth on y'all. We are looking at these for the first time. Okay, and then the last one's from June 5th. Started from the bottom, now we're here. All right. Email threads. Great. From Mark Diller, Friday, May 22nd at 4:03 p.m. to everybody. Subject, O'Keefe versus Reed et al. The subject isn't even deposition. That is the vaguest of subject lines. Counsel, please note the following. Tuesday's deposition of Mike Wazowski is off while the O'Keefes and Reed teams confer on Reed's objections to the matter. We were notified that Ms. Collins and Ms. Bombardier need to reschedule the Thursday depositions. Given that all parties were already blocked for the day and our need to move depositions forward, we investigated and discovered that Colin Albert's deposition was canceled by the Reed team previously and never renoticed/subpoenaed to date. They asked for available dates. Albert's counsel has agreed to accept a subpoena and to appear next Thursday at his counsel's office for deposition. They kept saying the location is the same location as Rosenberg's office, well, also as his office. They're all in the same building. Can you imagine how awkward the elevators must be? Friday's deposition remains on calendar and has been confirmed and is going forward. Have a nice holiday weekend. Look forward to seeing you all next week. Diller. The response from Charles Waters on Tuesday, May 26th at 12:35 p.m. Mark, your notice of deposition relating to Colin Albert's deposition violates the rules of civil procedure and therefore is invalid. As a result, you have no right under the rules to proceed with the deposition on May 28th. Kieran, please see attached for service pursuant to Superior Court Rules 9A, our motion to compel relating to Colin Albert's deposition. Please provide your opposition in accordance with Rule 9A. Chaz. Not untimely. Mark, invalid. You have no right to go forward with this deposition. Invalid. Pesky Pirouette said from Monsters, Inc., I don't well pronounce the last name. I think it's Mikowski. And in my brain, it just sounds like Mike Wazowski. So yes, that was just me being hyperbolic. Colleen said, was his response? Bruh, basically. Bruh. His response is basically, dude, what the fuck? So that was on May 26th at 12:35 p.m. And then Chaz forwarded that to others with FYI at 5:21. And then Kieran responded to Seligson on June 4th in the same email thread. Hey, Damon. I understand that you spoke with Jim today about the misrepresentations made by Aaron in open court during yesterday's wrongful death status conference regarding the facts surrounding Colin Albert's deposition and document subpoena. Please advise as soon as possible whether Aaron or any other member of your team intends to rectify or clarify those statements with Judge G. Otherwise, we intend to cross-move for sanctions against Aaron for violating Rule of Professional Conduct 3.3a when serving our opposition to the outstanding motion to compel tomorrow. I look forward to hearing from you. Well, they're still asking for sanctions. But also, why are we having not the attorneys involved in the thing? Why is Attorney Murphy reaching out to Seligson to talk about a conversation that Jim had with Aaron? What in the junior high locker, like, oh my God, I just need to tell you. We were talking after class. Did you hear? Jim and Aaron had a conversation. Why aren't Jim and Aaron the ones emailing? It's giving pass me a note after class. It's on the same email chain that Rosenberg is on. Like, what in the passive aggressive emailing is this? Rosenberg, Thursday, June 4th at 4:45 p.m., 5 minutes later. So Kieran reaches out to Seligson to talk about a conversation Jim and Aaron had. And Aaron Rosenberg's response to it is, you guys are really something else. He literally emailed back with girl. You guys are really something else. What misrepresentations might help to lay out what you allege to be misrepresentations before accusing your opposing counsel of lying? There's no salutation on that one. Then, June 4th, 5:01. Oh, like 6 minutes later, 5:01 p.m. This one's from Jim to Aaron. Aaron, I spoke with your partner, Damon, at length today about this. You said yesterday in open court that Colin Albert refused to appear for deposition. This was demonstrably not true. Our email exchange confirms that Ms. Reed canceled the April 29th deposition. That misrepresentation has had real-world impact as Colin and my other clients have faced an onslaught of online harassment, defamation, and intimidation sparked by your statements yesterday. Damon indicated that he would speak with you and get back to me with an explanation, if any, which I told him that I would listen to. I remain willing to do so. Jim. Dude, if you sidestep a conversation with me to talk to my colleagues about something I said, it is going to piss me off. And I'm sure it is going to piss most people off. Why? So that was June 4th at 5:01 p.m. June 4th at 6:25 p.m. Jim. Damon did not leave your conversation with any understanding of what quote unquote misrepresentation you were referring to. I don't believe I quote unquote misrepresented anything. But now that you have identified to me what you claim to be inaccurate, I am willing to review the record of the status conference and evaluate whether I think that I misspoke. If so, I would of course correct the record. However, as you know, there were two ways for you and your firm to handle your concern. You could have sent an email to me, the lawyer you believe misspoke, identifying it and asking me to correct it. Instead, your firm elected the first contact with me regarding this issue to be a threat of sanctions and allegations of an ethical violation, still without any explanation. I take it from your unnecessary and discourteous aggression that you stand by every word you've said and written in this case. So we'll follow up with you later regarding multiple statements in your recent reply in the federal case and your defamation complaint that are demonstrably not true. I'll let you know by Tuesday morning whether I believe any of my statements at the status conference warrant clarification. Thanks, Aaron. Oh, you'd like to do this? You would like to play games. Does that count for you, chat? You let me know. Does it count for you? This whole interaction, does this clock to you as gamesmanship? The lawyer is mad about something Rosenberg said. So lawyer Jim goes and talks to lawyer Seligson, and then other lawyer emails Seligson to follow up, and nobody talks to Rosenberg. Does that come across to you as gamesmanship? You let me know what you think. And Rosenberg's like, bro, what the fuck? That was June 4th at 6:25 p.m. Jim, all of you are just like, 100%. I know, it's giving housewives. Jim, June 4th, 7:13 p.m. to Aaron. Aaron, I do not want to play a game of telephone. Fuck off. I do not want to play a game of telephone. Then why are you engaged in a game of telephone? I don't want to engage in a game of telephone. Then why are you? Speak with him directly. I do not want to play a game of telephone. I raised these concerns in detail with Damon after the meeting, and he indicated that he will be the person we will discuss. What? Aaron, I do not want to play a game of telephone. I raised these concerns in detail with Damon after the meeting, and he indicated that he will be the person we will discuss on this issue. Dude, Grammarly. That is why Kieran's email was directed to Damon. We spoke for a while, and I spoke in detail about our concerns regarding the specific statement, even telling him about the real-world consequences of your misstatement. He told me, from his perspective, there was no intent to misrepresent, and that he represented to me that he would look into it and get back to me. If he is telling you something different, that is disappointing, but I will await to hear from him directly before I assume there is an issue. From our perspective, the statement you made had no defense or basis in fact, but as a professional courtesy to Damon, Damon's our favorite. Fuck you, Rosenberg. Good Lord with the bitchiness. We like Damon. You can fuck off. But as a professional courtesy to Damon, I told him that we would be willing to hear what he learned talking to you. Our deadline to oppose the motion to compel is tomorrow. So if you will not agree to a corrective filing or give a valid explanation for what you said, we will be forced to cross-move for sanctions. There is no other time given the deadline on your motion to compel. Indeed, that is the procedure Defendant Reed followed in seeking sanctions in connection with plaintiff's motion regarding Reed's phone. The statement is very short and the issue is very clear, documented by email correspondence that reflects that Colin did not refuse to appear for deposition. Damon, as we discussed this morning, please get back to me tomorrow so we can discuss further and see if we are able to reach an agreement on this issue prior to our filing deadline. Oh, this civil law is never short of you suck emails. Dear lawyer, you suck. And because you suck, this response. Lawyer, in fact, I do not suck. You suck. And these are the ways in which you suck. A.Ham. I'm waiting for them to get to I remain your obedient servant. I'm waiting for that to show up in one of these emails. Rosenberg, look. based on my history with all of these cases, I know the lawyers watch. At one point, just hear me out. I remain your obedient servant, A. Rose. I'm just saying. It seems appropriate given the emails that we are now treading upon. We haven't even gotten to a govern yourself accordingly. I know, Lyndon. June 4th at 7:13 p.m. Also, if y'all wonder why civil lawyers are always mad, it's this kind of shit. Artisa said maybe in an email. Oh, no, I think it should definitely be in an email that's going to end up in these pleadings at some point. No, I definitely think the I remain your obedient service, A. Rose, should be in the emails. I do not think it should be on the record. Rachel said, Emily, is this behavior normal for civil cases? Yes. If anyone wants to know why civil cases take so long, this. Lyndon said the silver lining is that civil lawyers love this. Oh, yeah, they love it. This is the dopamine. This is the civil law dopamine, is this kind of pissing matches. I fucking hate this. I hate this. It is such a waste of time and energy. I hate all of it. Hey, y'all, we're lawyers. We're on a case. We have shit to get done. Can we just get it done? I hate all of this. I don't want to fight with fucking people over email. Nope. Wait, wrong nope. Hold on. Where's the better nope?
Nope.
Yeah, this is a nope. This is a nope for me. June 4th, 7:27 p.m. From Rosenberg to Jim. Wait, how many minutes is that? Not very many, because this one was at 7:13. 7:27. Jim. Are you saying that you are accusing me of lying to the court and are now refusing to speak with me about it, instead insisting that you speak to my partner in some silly attempt to suggest that you are going over my head? Oh my God, it's a great use of the word silly. Even considering your tactics thus far, that is an incredible level of unprofessionalism. This really, really, really gives a lot of context to why the letter Rosenberg wrote to the court read the way that it did. Just Rhonda said, I'm going to dub this the email chain of petulance. I'm glad the attorneys included it. I'm here for it. Andrew said, are the clients being charged for this bullshit? Well, on the billing sheet, it just says email to opposing counsel. I would imagine. No, Rosenberg, they're not saying that they're going over your head. They're suggesting, in fact, that your feelings should be hurt because Seligson is their favorite. Jim, are you saying that you are accusing me of lying to the court and are now refusing to speak to me about it, instead insisting that you speak to my partner in some silly attempt to suggest that you are going over my head? Even considering your tactics thus far, this is an incredible level of unprofessionalism. Yeah, and Rosenberg is standing up at his stand desk on all these hearings, so you're going to have to go pretty high to go over his head. I mean, we'll have to decide whose head we have to go higher over, Rosenberg's or Banfield's. Probably Rosenberg's. But we are in the full pettiness. As you know, Mr. Albert refused to produce documents, then refused to provide additional availability, then out of the blue claimed he would be unavailable for the entirety of our remaining discovery period, save for 2 or 3 days without any explanation. Then, within hours of you sending that email, the plaintiffs improperly noticed a deposition on a date you knew our office was unavailable. And for the first time, your office claimed that our subpoena was somehow invalid or expired. So I don't think that your client, through you and your firm, So I do think that your client, through you and your firm, certainly played games to avoid the deposition. Well, when you lay it out like that, I could just picture the lawyers just being like, Are you saying? I mean, he goes on to say, however, I told you that I will evaluate the exact wording I used and let you know whether I think it needs clarification. But your colleague first identified the issue to me, the attorney you are attacking, at 5 p.m. today, when you knew I was already out of the office. So I will do so early next week, as I said. Good boundaries, Rosenberg. You can stew on it. But your colleague first identified this issue to me, the attorney you are attacking, at 5 p.m. today. Yeah, the game of telephone is such fucking bullshit. So I'll do so early next week, as I said. If you are intent on attacking your opposing counsel as a perceived means to further your case, we'll respond as necessary. Oh, that's about as close as we're getting to govern yourself accordingly so far in these emails. That was at 7:27 p.m. James to Rosenberg, June 4th, 7:44 p.m. Aaron, no one is going over your head. I had a meet and confer with Damon on this, and that seems the appropriate route. In what fucking universe is that the proper, in what world is that the proper route? No wonder they're all so pissed at each other. How is it the proper route to go to the colleague and be like, did you hear what he said on the Zoom call? What the fuck? How do we ever think that that's the proper route? Haley said, when is court? When we're done with this. The emails have taken quite a minute. Also, the commentary on the emails and everything else, because this motion was 17 pages longer than it needed to be. No one is going over your head. I had a meet and confer with Damon on this, and that seems the appropriate route. I raised it with specificity, the exact phrases we had concerns with at 10:30 a.m. today, less than 24 hours after the statements were made. Again, our position is clear. It was an unequivocal misrepresentation to say that Colin Albert has refused to appear for deposition. That statement has sparked substantial and vicious social media backlash. Indeed, the court today seemed to understand what I was talking about when I tried to raise it this morning. The court directed me to raise any issue through a motion. The opposition is due tomorrow, so I have conferred with your colleague this morning, discussing with him our concerns and desired redress. I am awaiting the response he represented to me he would make. It is Defendant Reed that has created this schedule with tomorrow's deadline. There is no need for back and forth on this. I will wait for Damon's promised response regarding the statements made at yesterday's hearing, but we have a deadline tomorrow, as you know. Jim. Jim's like, nah, fuck that shit. I'm not talking to you about it. I am, in fact, talking to Seligson about it. After court, instead of going to Rosenberg, which is also fuckery. The very next day, Friday, June 5th at 6:12 a.m. Jim. I listened to the audio of the status conference and think that my single statement that Colin, quote, refused to appear was somewhat inartful in context, and I am willing to clarify that for the court by letter on Monday. Again, had you simply pointed this specific concern out to me, oh shit. Rosenberg, this isn't going to make it better, but I don't think you're trying to make it better. Now you're just shaking the hornet's nest. Again, had you simply pointed this specific concern out to me, the lawyer you were histrionically accusing of lying to the court in the first place, we could have avoided a lot of wasted time and energy. As you are well aware, when a judge asks specific questions about many matters at once, sometimes lawyers misspeak. The professional course to take when you believe a correction is warranted is to point it out to the lawyer in question and ask for the correction. but I know that's not how you or your team operate. Fuck. And will certainly keep it in mind in the future. You'll receive a copy of my letter on Monday. Best, Aaron. No wonder they're all pissed at each other. Because then they roll into court with all of this and you're like, damn, that letter is spicy. And now you know that Rosenberg's like, if you've got a problem to me, come talk to me. What are you talking to Seligson about? Talk to me. I talk back. Holy shit. Now we know how your team operate. We'll keep it in mind for the future. Exactly. That was it. June 5th, 6:12 a.m. Friday, June 5th, 9:09 a.m. James to Aaron. Aaron, I am going to avoid responding to your professional criticisms of me and our team. Given the grievous impact these types of misstatements have had on our clients in the past, especially when unaddressed, we have no choice but to take them very seriously and to avail ourselves of the protection that the rules provide. We appreciate your willingness to correct the record on this issue. Will we review your proposed filing with the court on Monday? And hopefully, we will review your proposed filing with the court on Monday, and hopefully we can reach an agreement. Oh, they wanted editorial on it. Oh, no. We will review your proposed filing with the court. In light of that, here is what I would propose. Our opposition to the motion to compel is due today and would have to include our cross motion for sanctions. Given your proposal, it would make sense for us to hold off on serving our opposition and any cross motion until Tuesday so we can see if we can reach agreement as to the appropriate remedy. Oh, you're asking for an extension of time? You're asking to continue it? See, a continuance because the things that you need to predicate your response on aren't in yet. Kind of like continuing a deposition until you have the documents. Weird. Anne says, wait, I missed these emails. They're part of a record. They're part of the filing. These are exhibits to the opposition to the motion to compel. Can we just continue our deadline? In terms of the procedure, given the severity of this issue, I raised this issue with Ms. Reed's counsel at the hearing yesterday morning, who was Damon. He indicated that he would address the issue with me on behalf of Ms. Reed. That is all. Best, Jim. That's not how you said it, Jim. But wait, there's more. June 5th, 10:58 a.m. Jim, this is from Aaron, A.Rose to J.Tux. Jim, it's easy to pretend to take the high road after shooting from the hip with attacks on your opposing counsel's character and integrity. I agree to extend your 9A deadline to Tuesday. You can review what I send to the court and decide whether you plan to continue baselessly calling me a liar to further your own ends. Aaron. Y'all? It is Hamilton. I'm waiting for him to be like, we can go to Jersey. We now have a duel. We now have a duel. The lawyers are fighting. And now you understand when they pop off at each other in court, it's because this shit is going on non-stop in the background. Though, Aaron, just a note. I continue to remain your obedient servant, A.Rose. I'm just saying it would fit. But wait, there's more exhibits. We're not even done yet. And then we need to get to court. Exhibit 9. Oh, more terrible photocopies. These are the purported undue online harassment. I have no idea which platform these are from, probably Twitter. According to today's O'Keefe versus Reed/Canton Bars hearing, Karen Reed's attorneys are preparing motions to compel against several witnesses, but the situation involving Colin Albert stood out. Reed's attorney, Rosenberg, told the court that, okay, and then somebody responded, oh good, Colin is going to learn how to murder more efficiently. They must have talked about the military then. I think it's an offensive statement to members of the military. However, the way that they were wringing their hands about the online harassment and devastating impact is not, I would have expected something else. That's the first one. Is that the worst one? That somebody is being rude? Is this the most severe harassment of somebody quipping? Okay. Sure. I mean, I guess if he can get through boot camp. Turtle Boy posted, so this is probably Twitter. Colin Albert has suddenly decided to join the army and will be unavailable to give a deposition in the Karen Reed lawsuit. Hopefully our country is a little safer now that we are being defended by a person who testified that an award-winning journalist speaking into a window, and I don't know what the rest of that is. And then the response was, does the army know that he was in the house? I thought they said the exhibit was the various online harassment. This is why we can't take you seriously. Look, when attorneys burn faith, you burn faith. If you hold up a photo of a prescription bottle and say, see, this is the date it expired, and that is not what the bottle says, you burn people's good faith. And when you post online harassment and say that this is the severe and crippling harassment, and this is what you post, it burns. I can't take what you say seriously. Okay. This is probably a retweet. Dodging your deposition to get sent to war. Good job, Colin. That doesn't make you or your family look ridiculously guilty. P.S. Everyone knows you're murderers. It says, P.S. Everyone knows you're murderers based on your own testimonies. Turtle Boy has nothing to do with that. Sue me. Okay. You guys said I skipped a line. And I didn't. I read the whole thing on the tweet. I can't expand it because it's just the worst screen cap of a photocopy of a whatever. Somebody else on Twitter said that now Colin Albert can kill legally. Guess who is fleeing in order not to be deposed to answer the tough questions? Just because you joined the service, it won't shield you from prison. It ends with bang, bang. The next one is Colin quickly enlisted. Will they get to him before he jets off with a clock emoji? It's amazing how some people can dodge a deposition with Olympic level agility, then suddenly discover a calling to serve when sworn testimony is on the horizon. Okay. The next one says, Colin refusing to appear. Why, Colin? Then saying you are only available for 7 days and that's it. What's up, Colin? And then bang, bang, which is I think, a callback to the things that came up in his cross-examination. If I am remembering correctly, it was on one of his like Snapchat videos or something. Those are referencing back, I think, to his cross-examination with his Snapchats. There was like a pull up or roll up, right? Regarding some kind of hockey something. Right. So it is also a callback with context from the trial for anyone who's like, wait, what? That's right. The last one is also a post or a reply to the same post that we saw earlier that says, nothing fishy about the timing at all. The McAlberts are hands down the dumbest yet most transparent criminals of all. First, they try to hide little collie bear and now force him to enlist and ship off to boot camp. Can't help but feel a little sorry for this now man-child. So that's the entirety of the exhibit with the online harassment. The online harassment. Y'all, words have to mean something. Words have to mean something. Words have to mean something. You can't say that this is the devastating online harassment and then share comments to one tweet. Because all of these, not all, most of these are comments to one particular tweet. Okay. Okay. I guess the Olympic level agility was deeply offensive. Perhaps. I can't fathom that. I don't know how that's harassing. I think people who have been harassed online would look at all of this and be like, you're fucking joking me, right? Because online harassment can be horrific. But I don't know where the examples of that are for this instant. Because I'm not seeing that on these filings. I just disagree with their characterization. I'm glad they attached them though, so we don't have to guess at what the harassment is. So yay for transparency. Sure. Yay for transparency. I guess. Sure. Yeah. I don't know. Ms. Tricia said more people probably seen the comments in the court papers than on Twitter. That's probably true. That's probably true. We have Streisand once again, but I don't understand. There was confusion. I thought the hearing on the 3rd was confusing. Because by the time we got to the end of the hearing, I was just like, wait, did he give a deposition? Did he not give a deposition? I was confused. I was not sure what the rest of the information was. And Colin Albert's lawyer was not there to clear it up. I was confused. However, I don't understand why this is such a big deal, other than trying to now say the lawyers breached professional responsibility and therefore you can't compel Colin to sit for another deposition. I just don't see any other explanation for that. It's really difficult for me to like wrap my head around why this is such a big deal. Because it seems that he sat for a deposition for the plaintiff's lawyers and not for Reed's attorneys. Okay. Fine. He's also still suddenly unavailable. All right. I'm going to look at the reply briefly and we're going to go to court. When we go to court, we will send out another app notification because I didn't think this document was, when I say we do first glances, I was not anticipating that this document would take me quite this long because the ridiculousness. Like the ridiculousness. But alas, here we are. All right, let's look at the reply real quick. I think the emails kind of told us the direction that the reply is going to go in. I think we kind of got the vibes of what the reply is going to be based on the emails, didn't we? The emails kind of gave us everything we needed. The emails are just like, are you fucking joking me, bro? Is this what we're doing? Is this really what you want to do? Rosenberg's like, I mean, if this is how you want to play, this is how we'll play. Like, I mean, you want to do that? Okay. 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 Sure. Let's do that. So let's swoop real quick and then we're going to go to court to Reed's reply to Colin Albert's opposition to Reed's motion to compel Colin Albert's deposition and document production. Well, I can't say it's not feisty to start with. Defendant Reed's reply in support of the motion to compel Colin Albert's 20 pages of hyperbolic and various ad hominem attacks can be boiled down to the following admissions, which is all the court needs to know to allow the motion. This is the thing. You open yourself up for looking silly when it is so hyperbolic. Colin Albert was served with Karen Reed's deposition and document subpoena on April 26, 2026, op page 6. Right? Because it said counsel of record. Colin served a timely objection on April 7th, refusing to produce any documents. That same day, Reed's counsel requested a 9-seat conference and indicated that he would wait to depose Colin until after Colin produced the documents in order to do so efficiently and cooperatively, i.e. not requiring Colin to appear twice. In response, I love that it's bullet pointed. In response, Colin's counsel asked if Reed was canceling the deposition scheduled for the 29th. Reed's counsel explained instead that the deposition will be rescheduled to a different date. The next day, I love a bullet point. The next day, April 28th, the parties conferred regarding document production and on April 29th, Reed proposed a revised scope of production. Colin's counsel never responded. Colin's counsel did not respond until May 20th, and this is the problem. This is really the heart of the problem, is that they said, this is the revised scope of production, give us dates to continue the depo, and then they just ghosted. Colin's counsel did not respond until May 20th, just before 10 p.m. that evening. For the first time and without any explanation, Colin's counsel indicated that Colin would only be available for deposition for the next 13 days. Counsel offered 2 possible dates for deposition within the 13 days that followed. That's the problem. On May 21st, Reed's counsel, who had prepared to take Colin's deposition, informed Colin's counsel that he would be out of state traveling on those 2 dates. Because it was like the 28th and 29th, right? Colin's counsel did not respond. Rather, shortly later, on May 22nd, plaintiff's counsel served a deposition notice for the first time for Colin's deposition for 6 days later in direct contravention to Rule 30b-1 during one of the 2 days that Reed's prepared counsel, who had subpoenaed Colin's deposition a month earlier, had already indicated he would be out of the state. The timing of that, to me, is giving fuckery. Counsel for Reed says, hey, here's our proposal. What are we going to do? Ghost. And then all of a sudden urgency. He's just available for the next 13 days. We can do these 2 days. Counsel responds with, I am unavailable those 2 days. And then suddenly, out of nowhere, plaintiff's counsel parachutes in with a subpoena and is like, we'll do the deposition on the days you're unavailable. Come on. They then go on to say that on May 22nd, Colin's counsel finally responded to Reed's counsel on May 22nd and said that Reed's subpoena had, quote unquote, expired. Despite Reed pointing out that plaintiff's violation of Rule 30 and the obvious coordination at play, plaintiffs proceeded with an invalid deposition on the date Reed's counsel, who had prepared for the deposition, stated he was unavailable. Despite these admissions, Colin now argues that it is unreasonable for Reed to insist that he appear for deposition at a date pursuant to her subpoena. That is exactly the point of Rule 45. Reed has always been willing to accommodate reasonable scheduling issues that Colin has, but that does not include accepting the exact and only 2 days his counsel proposes less than 2 weeks ahead of time when he knows Reed's attorney, who prepared for the depo, is unavailable. The other part of this is, though, that having another attorney prepare for deposition is also a bunch of billable time that those attorneys need to be billing elsewhere. It is a unnecessary use of resources. And when you are dealing with this much litigation, not having another attorney spend hours prepping for a depo when one's already prepped makes sense. It's also the reason that I think the plaintiffs put off doing any depositions until the stay was lifted to conserve resources. They go on to argue that that's not how the rule works, and then says, oh, look at how brief this is. This is lovely. Emily, we're not going over the whole thing. Also, Emily, oh, it's 3 pages. Great. They say that Colin argues that Reed's subpoena expired and that she somehow engaged in sanctionable conduct by opting to reschedule Colin's deposition rather than deposing him twice, once without producing documents and the other one after he produces the documents. This argument is nonsensical and is designed to obscure the gamesmanship that is occurring. Footnote 1. Unless the court wishes Reed to respond more directly, Reed won't take up the court's time with the meritless accusations of misconduct that are strewn across Colin's papers, other than to state that Reed and her counsel have nothing, italicized, to do with unidentified individuals on the internet who commented on Colin's deposition scheduling. This remains simple. Reed seeks an available date in the coming weeks for deposition pursuant to her April subpoena so that Colin's unavailability after he was served with a valid subpoena does not hamper the discovery process or deadline in this case and does not prevent her from having her chosen counsel, who prepared for and intends to take Colin's deposition, be able to do so. 2, documents responsive to the narrowed version of the April subpoena rather than the limited representations and self-selected documents Colin has offered. The court should allow the motion, period. And with this background, we now go to court yesterday afternoon. I am so glad we did this in this order. The beginning of the opposition was spicy. I did not think it would go off the rails the way that it did and include all the emails. That's fantastic. So when Lord Castilian in the chat asked, how, pray tell, does a subpoena expire? It can expire if the deposition's not taken and there are no efforts to continue it. You can't then go to somebody 6 months later and be like, hey, now we're scheduling your deposition. This is not that circumstance. There were conversations ongoing to continue the deposition, but they're saying, no, the depo date passed, therefore it expired. You have to redepose him. You have to reserve him. And now that he's unavailable, service would be a problem because now he's unavailable. So it's with this context that we go to court yesterday afternoon. We have the lawyers fighting. We have the lawyers trying to sidestep having direct conversations in this email chain, sass all over the place, and online attacks saying that Colin Albert is avoiding his deposition with Olympic level agility. I'm not being hyperbolic in that. For everyone that is watching this on the case brief, I'm not being hyperbolic on that. There was a lot of hyperbole in the motions. That is what they said. So the lawyers have been fighting back and forth on this. What are Reed's attorneys asking for at the end of the day? Reed's attorneys are saying to the court, you need to make Colin Albert sit for a deposition before discovery closes in this case in August. And you need to make him respond via court order to the narrowed scope of discovery. Because I do agree with Colin Albert's attorney that the initial scope of the subpoena was overbroad, which is why the attorneys are like, we can narrow down the scope, but we're not narrowing it as much as you say. That's what Reed's attorneys are asking for. Make him sit for the deposition before the close of discovery. Make him respond to the document requests that has been narrowed down. Colin Albert's attorney said, we already sat for a deposition on May 28th with plaintiff's counsel. Reed's attorneys chose not to show up. Not our problem. He already sat for a deposition. Reed's parties, they allege, are engaging in gamesmanship, and they say that the court cannot compel the deposition and the document discovery as a sanction to Reed's attorney's alleged professional rules violation when Reed's attorney Rosenberg said at their status hearing on June 3rd that Colin had refused to appear for deposition or something of that nature. What they did not ask for is that Reed's motion be denied because the subpoena was no longer valid. They threw sentences in there, but when they got to the conclusion of their motion, they said it should be denied as a sanction against Reed's attorneys for their conduct on the June 3rd hearing, not because the subpoena was expired. So even though they tried to weave it in, that's not what they're really asking for. They're asking for a discovery sanction based on Rosenberg's statement, which is then how we ended up with Rosenberg submitting a letter to the court saying, this is my requested clarification in document 111 that we've already gone over. And then the court yeeted that document off the docket and said, what are we doing? We do not docket letters to the court. But it apparently was very important to Colin Albert's attorney that be done. And then the court has a hearing at 3 p.m. on June 17th on the motion to compel. It had seemed when this was docketed that it was going to be a Zoom hearing. It was not. It was an in-person hearing. And thankfully, there were cameras in the courtroom so we can view this hearing together and hopefully get to the bottom of it. Though that's not going to happen today. So, law nerds, Miguelina, will you send out a notification to the app that we are going to get to yesterday's hearing? That was a very long, what the fuck is happening in this case. However, the context of the drama, I think, is important. The context of the drama is important. So, let's get to the hearing from yesterday. We're going to fly to Massachusetts. And we're going to go to court. You guys ready? Let's go. All right. Let us get into court. As I said, this is and I don't know if there's been more this morning, but this was the only version of the hearing that I saw yesterday from one set of cameras. Emily, did you see that there's two parts of the hearing? I did not see that there's two parts of the hearing. I only saw one part to the hearing and I sound balanced it. But let me go look real quick and see if there's another one. Because if there's another one, I'll go grab it. Let's see. I grabbed what aired yesterday. Let me see if I can find it. Canton Community TV has the first part. I'll go look. But that one, okay, I'll go look, but it will not be, well, it doesn't matter if it's sound balanced. Let me go look. So, let me see. Because again, I was prepping this last night. It was posted this morning. Then that makes sense. Let's see. Oh, look, thank you, chat. This is why we do things live, because the chat can be like, hey, we got you. This says full hearing. All right. Well, it's very helpful that this one says full hearing. And we will go to the full hearing. I might switch halfway through to the point where I also gained up the court. If that's helpful to us, we'll see how the sound is. So I might switch it, I might not. But again, this is helpful because I tuned into this hearing yesterday. Again, I thought it was going to be on Zoom, but now we have the full hearing. Look at us. Thanks, chat. Chat is bae. That's why we do this. You guys are the best. The hearing got clipped 11 minutes. That makes sense. The audio is horrible. Here's what I will do. Let me also grab the one that I sound balanced. We will watch the one that is apparently the full hearing. And then when we get to the part that I had from yesterday, I will switch to the one that I've sound balanced. Sound good? So we'll deal with the terrible audio at the beginning, and then we will switch. Fair? Fair. Perfect. And I do not see that. Oh, there it is. It's at the bottom of my notes. I need to put this at the top of my notes. All right. Give me 1 second, chat. Sorry, my notes were running the wrong direction. It was a long day yesterday. Let's go to court. Chat, you're the best. Thank you. Wait, that's the wrong one. We don't want to do that. That's what we want to do. All right. Let's shift court just a little bit so that nobody gets mad at us about their logo. Let's put our hearing up. What was yesterday? The 17th. All right. There we go. Now we can go to court. Look, we'll fix it in post. Live streaming's dynamic. Live streaming, like court, is dynamic. And we'll see how we do with the audio. I couldn't hear the judge at all yesterday. Hopefully it's better today.
So let's start with plaintiff's motion to compel responses.
All right. Let's start with plaintiff's motion to compel responses. Emily, get your notes. We were busy finding the other part of the hearing. Thanks, y'all, for letting me know I was there. I love it. All right. Let's go.
And let me start out with a question.
I'm going to look for my...
Read.
The court's saying, let me start out with a question. I'm going to try to figure out where my closed captioning is real quick because it is, I don't know why it's not showing up. So give me 1 sec to grab my closed captioning because it should be showing up.
Attorney Rosenberg.
There we go.
In your opposition, you're basically saying the motion is moot because you responded to requests on May 21st.
I don't think that's what they're
Right.
saying.
As of filing that, yes, but I have an update that we
Hang
both
on.
have for you.
You go on to say in an email that's attached here, I should also point out, in the submission that you made, you pointed out to the clerk that some of the exhibits that you had submitted were not complete copies. So for the record is clear.
The reason the court is saying that some of the copies are not complete copies is because the party making the motion, Reed's parties making the motion, they're the ones who file everything. So they file Reed's motion, Colin Albert in this case is opposition, Reed's response, and then all the documents. So they file all of those. All right.
You submitted complete copies of 3 exhibits that the court has substituted for what was in there because they weren't complete, correct?
Correct. I think that relates to the other motion, however. But yes, that's correct, Your Honor.
Right. So in your, there's an email in there as well that you say there will be a future production.
That's the update I have for you.
Is it all produced?
Yes.
Do you agree?
To be clear,
All right, let's just back up real quick because they are not, I misspoke. They are not talking about Colin Albert's motion yet. They are talking about a different motion. Give me 1 second. That's on me. I was like, wait, what? They are talking to plaintiff's counsel. Plaintiff's counsel is in the gray suit. Colin Albert's counsel is in the darker suit. Reed's team, Rosenberg, is sitting on the other side. This is the courtroom we normally see via Zoom, I think.
So let's start with plaintiff's motion to compel responses.
And that was me. Plaintiff's motion to compel responses is not Reed's motion to compel deposition. Different motion from the O'Keefe parties to the Reed parties. Different motion. That's on me. Apologies. Because there are so many litigations. There are times when I get the parties mixed up. Plaintiffs in this case are the O'Keefe parties.
And let me start out with a question to the Reed group. Attorney Rosenberg, in your opposition, you're basically saying the motion is moot because you responded to requests on May 21st.
Yeah, this is an older motion to compel. We've gone over this older motion to compel. And yes, that's exactly what they argued. They said, Your Honor, we don't need to compel the discovery because we've been turning it over, and we've told them we've been turning it over. We've covered that motion a few weeks ago. But time is a construct. But yes, they said, Your Honor, this motion to compel is silly. Do you remember this one? This motion to compel is silly because we're in the process of compelling. And this is the motion where the plaintiffs, Reed's side, alleged that the O'Keefe plaintiff parties didn't follow up with them and that the discovery request had not gone to Rosenberg. It had gone to somebody else. And Rosenberg was like, hey, y'all, you didn't send me this directly. I was not on the email chain. I'm the one handling discovery for this case. I didn't see it. If you had just reached out to me and asked where the discovery is, then I would have said, oh yeah, here's the discovery. But you filed this motion to compel, and that's silly. We missed it. So yeah, our bad that we missed it, but you didn't include the lawyer doing the discovery on the email chain. And I'm sure that was inadvertent, but then you waited like 2 weeks, or you waited 2 months past the deadline on the discovery and then brought a motion to compel and said, but they didn't give us the discovery. And he's like, we're giving you the discovery now. It's that motion. We went over that a few weeks ago. So that's what the court's asking about now, is the O'Keefe motion to compel discovery from Karen Reed, the inadvertently missed one, that one. All right. Hopefully that helps.
Right?
As of filing that, yes, but I have an update that we
Hang
both
on.
have for you.
You go on to say in an email that's attached here, oh, I should also point out, in the submission that you made, you pointed out to the clerk that some of the exhibits that you had submitted were not complete copies. So for the record is clear, you submitted complete copies of 3 exhibits that the court has substituted for what was in there because they weren't complete, correct?
Correct. I think that relates to the other motion, however. But yes, that's correct, Your Honor.
Right. So in your, there's an email in there as well that you say there will be a future production.
That's the update I have for you.
Is it all produced?
Yes.
Do you agree?
To be clear, I can't give you a definitive yes or no, Your Honor.
When did you get it?
Well, to the court's probably dismay, we were actually in a...
Okay. Did you get the discovery? Well,
deposition this morning, which is nice to report. And
That wouldn't cause dismay.
yeah, I wasn't sure. I knew you might cause shock. I didn't know if dismay would come along with it. But that being said, Attorney Fell, my colleague, and I were in attendance for this morning's deposition, and Attorney Diller is unavailable at the moment. I received an email on or about 11:24 a.m. this morning from Miss Reed's counsel acknowledging that a production to our supplemental...
Your Honor, we can neither confirm nor deny the discovery without the Secretary's approval. Okay. I agree with you. I like Attorney Buck. Attorney Buck is the one there that on Zoom hearing a few hearings ago, the court was like, anything to say, Attorney Buck? He's like, nope. I've learned it's much better to keep my mouth shut with this group. I liked Attorney Buck. But Attorney Buck's like, yeah, they say they turned it over, but I can't tell you it's all been turned over because I don't know. I haven't gone through it yet. Okay.
Request had been made. Following the completion of today's deposition, I got in the car and came here.
Let's not waste any more
Yeah, I
time on
can't
this.
confirm.
All right, you don't know, you just got it, you just
It sounds
said
like they just got it that
Our
day.
team, yes.
your team.
Yeah, yeah.
Well,
Okay, that's kind of fair to Attorney Buck, though. It was turned over that morning. And he's like, Your Honor, we got the notice that this has been turned over this morning. We were in deposition and now we're here. So we haven't had a chance to check it. That's fair.
we'll use the collective.
All right, good, yeah,
okay?
that's fair. You're
All
right.
right.
Yes.
All right, so let's move on. We're done with that for now. All right? Anyone need to be heard any further?
Not this time.
Do you need to be heard any further?
No, Your Honor, not on that motion.
Okay, so let's go to the next motion. And that's the motion relative to compelling Mr. Allard. So
Okay.
Attorney Rosenberg.
And now we are moving on to the motion to compel Colin Albert's deposition. So the court was checking back in. Hey, you said discovery was ongoing. The motion to compel was not needed. Did you get the discovery? They say they gave it to us this morning. We have been in depositions and are now in court. We haven't checked. Fair.
And I guess to all the attorneys in this case and non-parties that are involved in the case, the pleadings I'm getting in this case, and I'm sure that I will get in the McCabe case, are replete with arguments presented as facts.
Children! Replete with arguments dressed up as facts. Yep.
Replete with arguments presented as facts, which isn't really helpful to me. And there's a lot more background in these submissions than I really need to decide the issues. So I'm going to ask all of you in the pleadings that you file, at least with me, just write what I need to know in order to decide the issue.
Oh, he's not wrong. Your Honor, my favorite turn of phrase on this would be counsels. All counsels. This level of hyperbole is unhelpful. And then, Your Honor, if they do not do that, start striking their motions. Just start striking their motions. This level of hyperbole is unhelpful. I agree with you, Your Honor. I mean, not to say that the tea is not scorching, but it isn't helpful. It's exhausting. Also, it is exactly what's happening. Pat Ray said, what about the other side? Oh, he's talking to all the attorneys at the moment. He's talking to everyone filing. He's talking to everyone filing. He is not talking to one side or the other. He is saying to all counsel, stop it. This is him telling all of them to rein it in.
And stop pandering to social media. All right? So now let's get on to your motion. And I have a question with respect to your motion that you wrote.
Can I just make one quick comment, Your Honor? Our memo, I agree with you, but our memo of law is 9 pages long, and it has a page and a half of argument. So we're not pandering to anyone, and we don't intend to.
You raised it, so let's talk about it. Let's
He's
go
not
to page
talking
3
to-
of your motion.
Rosenberg. Rosenberg. He wasn't talking to you. He was talking to everyone. Don't argue with him. This one let's slide. It's pretty obvious that the opposition is kind of what fanned the flames on this one. Just let it be. Because here's the thing. When the judge is speaking broadly to all attorneys, the next lawyer to speak is going to catch the rest of the smoke, I imagine. Don't do that. Don't do that. But I understand if I'm Rosenberg and the court in the very last hearing had talked about Reed's team not giving Proctor a heads up about a filing that they're not obligated to give a heads up to, and talked about Reed giving an interview, I think I also might be a little prickled by the court starting to insinuate that all sides were a part of it. I think I would also want to say, Your Honor, they did it more. I can understand the impulse. Your Honor, but they're doing it more. So we'll see.
All right. And top page, we don't have to restate the words, but end of the first sentence to the end of the second sentence, end of the first line, not to the end of the second line. All right? Now, how old was that individual when they went to the wedding?
I don't know, Your Honor, but...
So is it really, you don't know, so is it really, what if he was a ring bearer? Is that really relevant to the issue I have to decide?
Absolutely it is, because...
If a young child's a ring bearer at a wedding, okay, go to the line above there, okay? The words in quotes. Whose words are those? Because there's no reference.
Oh boy. Well, I think Rosenberg stepped in it a little there. I understand that what he's trying to do, but the court was mad. The court admonished everybody. And now Rosenberg's like, but Your Honor, ours was 9 pages and they responded with all of this. And the court's like, oh, okay, let's go line by line. Okay.
No citation to it, which makes it totally not helpful to me.
Understood, Your Honor, and that point is taken. However...
Well, who is it, do you know?
I believe it's her defense counsel.
He didn't write the motions.
Her defense counsel. You're citing a statement in quotes from your client.
I said the same thing. Okay, Your Honor, I hear you on this. I said the exact same thing. I said the exact same thing yesterday. I get it. I said the exact same thing. Who said pin it on the girl in quotes? And Rosenberg checked with counsel and he's like, her defense attorney? Right. That's what the court's asking about. I understand where Rosenberg is just like, hey, Your Honor, don't start none, won't be none. And then the court's like, fine, it's everyone. And I don't disagree with the court that it's everyone. It's everyone. Trigg said, but is he harder on Reed's team? I think today the next attorney that opened their mouth is the attorney that was going to catch this from the court. Because the court's mad at everybody. I said this yesterday when we were looking at this motion, because there are things in the motion that don't need to be in the motion. And the court is trying to get everyone to narrow down these motions and stop slinging mud at one another. And both sides have done it. The court was telling both sides to knock it off. Rosenberg was like, but Your Honor, wait a second. He's like, nope, I'm not the one. Rosenberg stepped in it. I understand why he did, but I think the court was willing to leave it alone after telling everyone to knock it off. Right.
Understood, Your Honor, and that point is taken. However...
Well, who is it, do you know?
I'm going to back up to what the court's talking about, because I believe the court's talking about the pin it on the girl comment immediately, because he's like, this isn't helpful. It's a direct quote with no citation. I had the exact same criticism.
Individual when they went to the wedding.
I don't know, Your Honor, but...
So is it really, you don't know, so is it really, what if he was a ring bearer? Is that really relevant to the issue I have to decide?
Absolutely it is, because...
If a young child's a ring bearer at a wedding, okay, go to the line above there, okay? The words in quotes. Whose words are those? Because there's no reference, no citation to it, which makes it totally not helpful to me.
Understood, Your Honor, and that point is taken. However...
Well, who is it, do you know?
Who said it?
I believe it's her defense counsel.
Her defense counsel. You're citing a statement in quotes from your client's defense counsel. How is that relevant or appropriate, especially without citation?
Right.
But if I could take the first question first, and then I'll answer your second question. The first question, there's a significant relevance objection to Colin Albert being deposed or producing any documents in this case. You see it throughout the lengthy opposition.
I don't think the opposition is to producing any documents.
I would disagree with that, Your Honor, and I'm happy to explain why. But there's a significant relevance objection overall to Colin Albert being a
I know
deponent.
there's a relevance objection, but I don't think facts or claimed facts like that are really relevant. They're nothing but attempts to sensationalize certain things. So let's go on to the real issue.
Your Honor.
The court wants everyone to tone it down. The court wants everyone to tone it down. And I understand why Rosenberg's like, well, not everything in here needs to be toned down because the court needs to understand the context. From the court's perspective, I imagine what the court is looking at, because now the court is assigned this case and the defamation case. The court is like, if y'all don't knock it the fuck off. Because what we don't need is an opposition that is 1,000,000 pages long, that is so repetitious, and we don't need everyone continuing to raise the temperature. Right. And Rosenberg's like, some of this is necessary.
No, let's go on to the real issues in the case.
Your Honor, if you're going to point out that something is irrelevant, I'd like to please just very quickly address why I disagree with you.
I've read everything. I know why you think it's relevant. You think it's relevant because they don't want to produce anything, and they're trying to minimize the involvement. You're trying to do the opposite thing. I understand that.
But you just told me you don't think it's relevant. I think I have the right to tell you why I disagree.
I don't need all that background, all right?
It's not background, Your Honor. It's a significant point.
Let's move on.
Well, how is the relationship?
Let's move on.
How is the relationship between?
We're either going to move on or we're going to end the hearing.
Okay, well, Your Honor, I would note for the record, I'd like to address the point that you just made, referring to something as irrelevant, which I think is actually highly relevant. If you're not going to allow me to explain that in 2 sentences.
You don't know how old the person was at the time.
And the court keeps doing that. This is not the first time we've seen the court shut attorneys down in this way. But I also understand where the attorneys are just like, but Your Honor, you keep saying things like it's not relevant, and I need you to understand why it's relevant. And the court's like, no, I understand why it's relevant. Then why did you say that? Because the court isn't always artful with his words. And we have seen him shut down lawyers throughout hearings with this, where the court throughout Reed's attorneys should have given notice to Proctor's attorneys, and Seligson kept trying to make a record. And the court was like, no, I've said what I've said. You don't need to make a further record. And Seligson's like, are we obligated to do something we're not obligated to do? And the court's like, I don't want to hear about it anymore. And then he did it with Diller when Diller was trying to get into something, because Diller had a prepared speech ready to go and he kept trying to get into it. And the court's like, that's not what we're doing today. Stop talking. So we've seen this happen a couple times, but the problem is that the judge keeps making comments that the attorneys are then like, no, we need to correct that perception. I get it, but it is just frustrating.
The time they attended the wedding.
Correct.
Okay.
But that doesn't impact the relevance. The relevance is the relationship between the families. That's the relevance, and that's the only reason it's referenced there. I don't think the fact that the families were close enough to attend weddings together is irrelevant to whether Mr. Albert is relevant to this case. But I'm happy to move on to your other question. I think, I don't know if you...
And again, the judge is letting him finish. This is not an uncommon part of lawyering. I know a lot of you in the chat are like, this is so uncomfortable. This is not an uncommon part of lawyering, where you have to keep going until your record's made. And did you notice the court let him finish? He was like, no, I need to finish making my point. And then the court let him finish. Right. If it makes you uncomfortable, litigation is not your vibe. But this is common.
Referring to something as irrelevant, which I think is actually highly relevant. If you're not going to allow me to explain that in 2 sentences.
You don't know how old the person was at the time they attended the wedding.
Correct.
Okay.
But that doesn't impact the relevance. The relevance is the relationship between the families. That's the relevance, and that's the only reason it's referenced there. I don't think the fact that the families were close enough to attend weddings together is irrelevant to whether Mr. Albert is relevant to this case. But I'm happy to move on to your other question. I think, I don't know if you need an answer, but I take your point about quotation marks without a citation and the effectiveness of including prior statements of counsel.
It is a fair point. I understand it's the theory of the case, but it's a fair point. You don't put a direct quote and then not reference it back. Fair.
Counsel and pleadings, and we'll keep that in mind.
Not helpful.
Understood.
So now let's go on to
He's
some
like,
other
heard.
questions I have about what happened here.
And notice, the court let him finish, and now they're moving on. Right. Heard, Your Honor. Fine. It's fine. Let's move on. I understand their point, though, because Colin Albert's attorneys are trying to say he is a minimally relevant witness. And Rosenberg is standing his ground saying this isn't irrelevant. He is not a minimally relevant witness, because I think the biggest point here is the notes they say of the investigators show that the investigators knew Colin Albert was at the house that evening and left it out of all of their reports. And that is a big issue. That does go to their theory of defense in this case. And interviewing, deposing Colin Albert regarding his whereabouts, when and what, is a big deal. So, right. But the court's also like, I get it. They're trying to say he's not relevant. You're trying to say he is relevant. Fine. But I think the court did this with Seligson too. I think the court's already decided that he's going to grant their motion and is cutting them off because he's like, I just want to get to the point that you're going to get a deposition. So why are you fighting with me? I'm going to give you a deposition either way. I don't think they know this judge well enough to trust that that's what he's going to do. Because with Seligson, the way he kept cutting him off was frustrating to watch. And then he was like, no, Proctor has to sit for his depo. I'm like, just let him make his record then.
Your office, not you individually.
Collective you.
Your collective you.
Yes.
Issued a notice of deposition on February 11th, 2026 for a deposition over 2 months later on April 29th, correct?
Correct.
Okay. And a subpoena was issued on April 15th.
Correct. Thereabouts.
No? Well, that's the date on it.
Okay,
You can
then
look at
yes.
it. Compelling production of documents 12 days later on
All right, why wait so
April
long?
27th. And the subpoena was not served for 6 days. Would you
Yeah, why
agree
wait
with
so
that?
long?
If that's what it says, I don't dispute the
Okay.
general point you're making.
So
Yeah,
my
why
first
wait?
question is there a reason that you would wait 2 months after issuing a notice of deposition to issue the subpoena?
Well, there were a lot of moving pieces schedule-wise, as you're aware, Your Honor.
No, the notice of deposition said the date of the deposition.
Understood, but obviously those change.
Why do
often.
you wait 2 months, less than 2 weeks, closer to 12 days, to
He
issue
said.
the subpoena and not serve it for
He said because there were a lot of moving pieces.
6 days?
Well, the service is dependent on the process server. I don't have an answer for you why it took 6 days.
No, it's not. The service is dependent upon the constable or whomever you hired to do it. Right?
Correct, Your Honor, but
That's
they're
what he
the
just
ones
said.
that go out and
So
try to
maybe
find
don't
people.
wait until 2 weeks before the deposition.
Understood, Your Honor, and I don't disagree with you. But when that issue was raised, in no form did anyone on our team say to Colin Albert's counsel, you have to get us those documents in the 8 days because that's what the subpoena says.
Well, that's what the document says. And I'm going to remind you of the provisions of Rule 45, which says a party or attorney, okay, responsible for issuing and serving a subpoena must take reasonable steps to avoid imposing undue burden or expense on a person subject to the subpoena. This is a non-party.
Right, why wait so long?
You served a subpoena asking for 4 years' worth of information to be served in a very short period of time.
And that,
I don't think that's complying with either the words or the spirit of Rule 45.
and that's why, Your Honor, I don't have a problem with that, and that's why when that issue
Why did
was
you do
raised,
it?
because there was a lot going on in the case, and it took longer to serve than probably we would have wanted it to. And so, Your Honor, when counsel raised that and said exactly what you just said, you've only given us 9 days to appear and 8 days to produce, whatever the specific numbers are, we said, we understand that. We are going to work with you on negotiating and conferring on the scope of the subpoena. And secondly, because of the time limit, we are going to reschedule the deposition so that we can resolve this.
Which is why it's now coming back to bite them in the ass, right? Because the court's like, why did it take so long to serve? And they're like, we gave our process server, we don't know why it took our process server 6 days to serve it. I wonder if Colin Albert's attorney didn't agree to accept service. I have questions, but they said that took longer than we would like, and we weren't holding them to it because we said we will work with you. And then they said we will work with you, and then the other side ghosted them for a month. And this is why none of the depots have gotten done.
Document production issue, including when a production would be made before the deposition, so that Mr. Albert doesn't have to come back twice. So I'm not fighting you on that, Your Honor. I agree. And when it was raised by Mr. Albert's counsel, they didn't get pushback on that, on the timing. And so I'm not defending that. It was an oversight, I think, and I would prefer that it had been served 30 days before.
With all due respect,
Fair.
to someone that's represented by 3 law firms and at least 10 attorneys, it's hard to envision that it was an oversight.
And this is what the court's been mad about. The court has consistently said there are this many attorneys on the team. Why can't it get done? I don't think that's necessarily fair of the court in context of the 4 ongoing litigations in 3 different courts. It's not as if there are 10 lawyers on this particular case. There are 4 cases in 3 different courts in 2 different jurisdictions.
A non-party deposition subpoena doesn't go out until shortly before the deposition and 2 months after the notice of deposition.
Your Honor, frankly, there's no basis for that. There's nothing intentional that has been done here. I agree with you, it should have been done sooner. And I apologize that it was not done sooner. And when it was raised by counsel, there was no pushback on that. And I think if you ask counsel, they will confirm that there was not pushback on the timing.
Let's skip down ways to April. And
I understand where the court would like this to happen faster, but then where is also the pushback on the motion to compel discovery when it was served and then there was no follow-up for years? Or not years, 2.5 months?
in May, and am I correct that your office knew of Mr. Albert's availability and unavailability in the month of June? Were you made aware of it?
When?
Were you made aware of it by Attorney Tuxbury?
When? At what point? Eventually, on, I believe, May 20th, the email is an exhibit.
May 20th, so...
And May 20th, just to be clear, the explanation that we received was between now, May 20th, and June 2nd, Mr. Albert is available. We propose, I believe it was May 27th and May 28th. After that point, Mr. Albert will be unavailable indefinitely without an explanation. Frankly, the first explanation that we received was in the motion,
That's
or
the
in the
first
opposition
time.
to the motion.
And that's the first time there was an explanation. There was never an explanation in the court filings about why Colin Albert was unavailable. It was, he's available till June 2nd, and then he's not available forever and ever.
And
So, yes.
I know you call into question the manner in which Mr. Albert's deposition was noticed by the plaintiff's attorney, and I'm not arguing with that. But am I correct that you had notice of that deposition?
Were we aware that the plaintiffs planned to proceed with their deposition? Yes.
Yes. And even if the notice may have been deficient, as you reference in your pleadings, you or your team, like you like to refer to it, made an intentional decision not to appear without coming to the court at all?
So, first of all,
That's a yes or no question.
well, I don't think it is a yes or no question, Your Honor.
Either in
We
the-
were aware, and we didn't.
Oh boy. Oh boy. I'm real curious. Real curious. To see what the response is to this, because the court's like, you had notice of the deposition, and the court said, I'm not quibbling with you. He didn't use the word quibbling, but I'm not quibbling with you about how this arose, but you knew and you chose not to go. Julie said, why are Karen Reed's attorneys the only ones getting pushback? Well, they're here on their motion, so they go first. The court hasn't spoken to the other side yet. So this is Karen Reed's motion, and they go first. So that's why the court is questioning them first. And this judge has been a bit like the appellate judges, where the person who's bringing the motion gets the most questions, and then the opposing side gets the other questions. We'll see. But the judge is like, so why didn't you appear? I'm curious about that too. Let's see what they say. They're saying it was not a properly noticed deposition. The court didn't push back on that, and the court didn't push back on the questions regarding the circumstances of how that came to be.
Position, yes.
Yes. And even if the notice may have been deficient, as you reference in your pleadings, you or your team, like you like to refer to it, made an intentional decision not to appear without coming to the court at all.
I
So,
think that's what the court's
first of
mad
all,
about.
That's a yes or no question.
Well, I don't think it is a yes or no question, Your Honor.
Neither in
We
the-
were aware,
Didn't.
and we didn't file a motion. But again, I'd like to address why that is, if you're going to raise the issue. May I address that?
He
I
asked.
know why you didn't, because you claim you wrote about it, why you didn't. It's in there, I read it.
Well, if you're asking about it at the hearing, I'd like to address the point.
Okay.
So what happened was we served the subpoena. As you say, we have a team of lawyers. Different lawyers are taking different depositions. The lawyer that's taking the deposition drafts, serves, and prepares the subpoena and prepares for the deposition. We did all of that. We complied with the rules, with your exception about date and timing is well taken, and it won't happen in the future. However, otherwise, the subpoena was fully compliant with the rules, and the rules require us to be able to take the deposition. We didn't say it has to happen on this exact date. What we said was we will reschedule it to another date. The recipient of a deposition subpoena doesn't get to choose when the deposition happens by playing games like were played here and are laid out in our papers. Mr. Albert's counsel was notified in this back and forth in the emails that are attached to the motion papers that the attorney who was prepared to take Colin Albert's deposition was going to be away on 2 particular days that they had proposed. That one of those days, 6 days later, is the one that the plaintiffs chose.
Right.
So the attorney who had prepared was not available, as was told to Mr. Albert's counsel. The notice, as you referred to, was issued in direct violation of Rule 30b-1. So we provided notice to all parties that we believed that deposition could not go forward pursuant to that notice, and we continue to believe that. But if the question is, did we come and file a motion for a protective order? No, because we don't believe we needed to.
Because they violated the notice.
Yes, sir.
When is Mr.
So now the court is like, a lot of you are like, why aren't they asking the other side? Because the court was going to finish with the questions to Rosenberg first and then turn to the other side and ask the questions. Court often does not ping pong between the two. It is, I want to hear this side and then I want to hear the other side. This side is bringing the motion. So that is where the court started. Also, Rosenberg kind of volunteered to go first when the court admonished all the lawyers about their filings. And he's like, well, actually, Your Honor. And the judge was just like, okay, fine, let's talk about you first. But Rosenberg's motion is first. So he bears the burden. He goes first. So now the court is turning to not the plaintiff's attorneys, but Colin Albert's attorney.
Mr. Allen going to be produced for deposition?
He won't.
If the court gets harder to hear, I have sound balanced the rest of this. The court said, when is Mr. Albert going to be produced for deposition? When?
Order? No, because we don't believe we needed to.
Attorney Tuxbury,
Yes, Your Honor.
when is Mr. Allen going to be produced for deposition?
He appeared for that deposition on the 28th pursuant to
Talk
subpoena.
about that one.
And then he is,
Hang on, let's lay the groundwork.
Yeah.
You agree you accepted a deposition subpoena?
This is Jim, who was fighting with Rose, fighting with Aaron via email. This is Jim. So this is the attorney representing Colin Albert, whose emails we were just reading when he was fighting with Rosenberg. Yes. Damn it, Jim. This is Jim. So Colin's attorney, when is he going to be produced? Colin's attorney's like, he was on the 28th. The court said, not that one. I'm not talking about that one. We know that I'm not talking about that one. Let's back up. And now the court is like, let's back up to the beginning.
he appeared for that deposition on the 28th pursuant to
Talk
subpoena.
about that one.
And then he is,
Hang on, let's lay the groundwork.
Yeah.
You agree you accepted a deposition subpoena?
he was served a deposition subpoena for April 29th.
Then you talked about taking it off. It didn't go forward. When's he going to be available?
At this point in time, Your Honor, I'm not sure. It'll be sometime in the fall. It'll be sometime in the fall. He's got 10 weeks training.
Not going to happen.
He's in
Court, when's he going to be available? In the fall. Not going to happen. Not going to happen. Not going to happen.
basic training right now. We have 1 hour a week communications with him.
And I don't dispute what you're telling me, but I'm not going to simply rely upon a statement in court that a witness can't be produced
Okay.
until the fall. So go find out when he can be produced before that.
Okay.
The court is very hard to hear. And the court's like, no, you are not waiting till the fall. Attorney represented he's in, what did he say, basic training, and he can't be produced. And the court's like, that's not sufficient. We can switch to the other video. We can. The virtual juror is like, can we switch to the other one? Did the court get harder to hear? Or no? It seems like the court got harder to hear. We can switch. Give me 1 second. If, yeah, it seems like it, all of you, yes. Okay. Let's switch videos real quick. And then hopefully it's easier to hear. All right. Just give me 1 sec to cue that up.
Yes, Your Honor.
When is Mr.
Hopefully it's easier to hear. Let's just switch videos real quick. I don't know why the quality on this does not look. Let me see. That should be in 1080. We'll see if it clears up. If it doesn't, I'm switching back to the other one because this looked much better yesterday. I don't know why it looks so much worse now. Hold on. That's what we wanted to do. Give me 1 second. All right, we're gonna back up a little bit because I'm switching videos. So apologies. I don't know what I just did. Sorry, chat. Give me 1 second. That was me. That was me. I'm sorry. There we go. Streaming is dynamic. Hopefully the sound is better.
Allen going to be produced for deposition?
He appeared for that deposition on the 28th pursuant to subpoena. And then he is,
Hang on, let's lay the groundwork.
Yeah.
You agree you accepted a deposition subpoena?
he was served a deposition subpoena for April 29th.
Then you talked about taking it off. It didn't go forward. When's he going to be available?
At this point in time, Your Honor, I'm not sure. It'll be sometime in the fall. He's got 10 weeks training.
Not going to happen.
He's in basic training right now. We have 1 hour.
I love the court. Not going to happen. Counsel's like, he's in basic training. When are we going to hear it? All of you are saying this sounds much better. Perfect. Not going to happen. The judge is like, just not going to happen. The discovery cutoff is in August.
Week communications with him.
And I don't dispute what you're telling me, but I'm not going to simply rely upon a statement in court that a witness can't be produced
Okay.
until the fall. So go find out when he can be produced before that.
Okay. I will, Your Honor. Try. We won't be able to talk to him until Saturday. I'll talk to him Saturday briefly and see what we can figure out.
Well, it's not a matter of figuring it out. It's a matter of you saying to him, there's a duly issued subpoena. As I said in one of my pleadings, in this case, which you weren't involved in,
Oh boy. The court's like, no. Don't try to figure it out. Go tell him you're appearing for deposition. You don't have to figure it out. Go tell him, get your ass to a deposition. I love that the court's like, no, you go tell him to get to subpoena because there is and you hear what the court is saying, there is a duly issued subpoena. So the court agrees that the subpoena from Reed's attorneys for the deposition is valid. And this is the court on the other side of this saying, why aren't you appearing for a deposition? It's a valid subpoena. So the court agrees with Reed's side that the subpoena is valid. You need to get him to a deposition.
a subpoena needs to mean something. Just as an attorney agreeing to continue needs to mean something. And it shouldn't
Stop trying to cut off the court,
in
bro.
front of me in these circumstances.
I appreciate that, Your Honor. We're in a situation where we learned on the 20th and we let them know the same day. I know they say there's games here.
In your filings, you said it was the 19th. In your filings, you said it was the 19th. In your filings, you said you learned on the 19th. And then on the 20th, it was like confirmed or whatever. But the court's like, no, you need to get this done.
We informed them the same day that we found out this information that he had been accepted into the military and had a shipment date of June 2nd. We said, please take his deposition during this period of time because I know you want to take it. And at that point in time,
Let's not put aside the fact that you represent him in another case.
certainly.
That
And
was called, that was filed not that long ago.
yes.
Oh boy. The court's like, but you represent him on another case. What do you mean you had no heads up that your plaintiff on a defamation suit was joining the military? Is he not going to pursue the defamation case? Because he's going to have to show up. He's suing. You represent him on that case. That case is also before this judge. So, come on, bro.
So certainly, maybe a party that's going to prosecute an action such as they have alleged should stay in touch with their attorneys and let them know what's going on.
Certainly. And we know what he's going through his first 3 weeks school. And then when this ends, he'll go to 10 weeks basic training. We're not sure where that will be. The Army will assign him that location.
But you just said he was in basic training. So he's not in basic training. These types of small shifts make me crazy. Maybe they don't make other attorneys crazy the way that they make me crazy. But when you first represent to the court, he's in basic training, he's unavailable. And then 2 sentences later, you say, well, he's in 3 week school. And then he's going to basic training. Which one is it? Those are not the same. It just say what it is. Why the gamesmanship? Just say what it is. So he's not in basic training yet. He's in this 3 week thing before basic training. And then he goes to basic training. It's so annoying. It's so annoying.
That long ago.
Yes.
So certainly, maybe a party that's going to
I had to back it up. It's so annoying.
such as they have alleged should stay in touch with their attorneys and let them know what's going on.
Certainly. And we know what he's going through his first 3 weeks school. And then when this ends, he'll go to 10 weeks basic training. We're not sure where that will be. The Army will assign him that location of where his 10 weeks of basic training will be. He'll be on, like I was saying, Your Honor, he'll be on leave in the fall. So in terms of
How do you know that?
Let me just make it clear. We're not waiting till the fall.
Okay.
All right? Discovery ends in this case on August 17th.
Okay.
So you're going to go find out when he can get back up here and be deposed.
Okay.
Now let's talk about the status of any discussion.
So as I said, The court's inclined to grant this motion. When is he going to get back up here and get deposed? And did you hear what the lawyer said? Hey, we only have like 1 hour a week on Saturdays, so I can't talk to him.
Between the attorneys as to the scope of the production. I agree with Attorney Tuxbury that the scope of the subpoena is excessively broad.
It is broad.
And I know there have been discussions, but I don't know where you're at now. Have you had any recent discussions?
No, the discussions are what are laid out. And
In the emails.
If Your Honor is inclined to ask us to, we can continue to work on the document side and report back to you in a few days.
Great.
Yes, I mean, we made our proposal, Your Honor, with respect to, issues about what this case is about, which is the death of Officer O'Keefe on the night of January 29th, 2022. He searched for all communications with law enforcement for the entire
Why are you filibustering? Okay.
period of time, look for other ones. We never heard back. We got this motion in response to that. I mean, we're happy to look at other stuff here, but I think to your point, the asking for private conversations, communications, really from our perspective is a non-starter without being tied to this case.
To you, Attorney Rosenberg, collectively, let's keep in mind, okay, that I know there's the other case, but you're talking about a non-party.
Understood, Your Honor. And I don't know if you would want to, but I'm happy to get some thoughts from you about because what Mr. Tuxbury is referring to is the extremely narrow two categories that they said, we'll search for these and we don't have any documents. We search and we don't have any documents other than the text chain that's already public record. So I think that is certainly too narrow. But I also take your point to me that as it stands, the subpoena is too broad. There is obviously, as you are aware, Your Honor, there's more than wrongful death alleged here. The false narrative is part of the claims the plaintiffs have brought in this case, and that obviously relates to much longer than January 28th and 29th, 2022. So
What Rosenberg is talking about is the IIED claims, the intentional infliction of emotional distress. He said false narrative because that's how it's posed in the filings. It's been a long time since we've gone over that filing. But he's saying, look, it's not just the wrongful death. There are all these other causes of action. Yes, there is wrongful death. There's also negligent infliction of emotional distress and reckless infliction of emotional distress. So not IIED. Negligent infliction and reckless infliction. And there are, let's see, counts 4 through 13 deal with negligent infliction of emotional distress and reckless infliction of emotional distress. So he's saying, look, this ties back to what Karen Reed was saying about those in the house is underlying the claims for emotional distress in some parts.
to the extent, A, there's
I
burden,
don't know that it extends 4 years.
and I'm not trying to argue it because I don't understand that you want to decide that as a fact right now. All I'm saying is it's broader, and this is kind of my point. I think it's broader than what Mr. Tuxbury and his team interpret it. You're telling us that you think it's narrower than what we interpret it, and that's taken, which is why I suggested we have a conversation about maybe meeting somewhere in the middle, and I'm fine doing that.
When can you have the conversation?
Tomorrow?
Sure. Yeah, I
Make them all go in a conference room now, Your Honor. Send them to a conference room and make them talk about it now. So now the court is just like, okay. And I understand what Rosenberg's saying. Rosenberg's saying, look, clearly the court said that the subpoena is too broad. I don't disagree with the court. But the way that they're narrowing it down is way too narrow. So they've got to come to a middle ground of what is reasonable, not too broad. No, they've got to find the just right. We got to go full Goldilocks. What is the just right amount of discovery? And the court is like, when can you talk about it? They should have done before they came to court. Tomorrow.
I'm open to a call anytime. Just call me. I'm available tomorrow afternoon. We have a meeting.
You seem so open to a call. We read the email chain before this hearing. I'm glad we did.
When can you have the conversation?
tomorrow?
Sure. Yeah, I'm open to a call anytime. Just call me. I'm available tomorrow afternoon. We have a meeting for something else tomorrow afternoon.
It's not me that has to call you.
I understand. It's anyone. Damon can call me. I never know who has to.
Poor Seligson has to be like, why you so obsessed with me? What is your thing with Damon? He's like, Damon can call me. Rosenberg's like, the fuck, dude. Come on, Jim. And you know what? When it comes to discovery with regard to Colin Albert, it's probably going to be Chaz that's calling you to figure out what the discovery is because he's the one doing Colin Albert's depo. But I love that the court's like, I mean, I don't have to call you. Why are you talking to me? Oh my God.
To call me because they have this allocation of attorneys, so you have to know who you're talking to. But
I think you're aware of who's allocated to what in this case at this moment. It seemed to me that the email chain made it clear. I feel like I'm aware of who's allocated to what just by reading that brief amount of emails.
It's not me that has to call you.
I understand. It's anyone. Damon can call me. I never know who has to call me because they have this allocation of attorneys, so you have to know who you're talking to. But yeah, I can have a conversation about that. But obviously, as you know, this is a wrongful death case with again, there's an intentional infliction claim based on a false narrative. In many respects, that false narrative claim is the other side of the coin of the wrongful death, right? If she has said things that someone else did it, and they show she actually did it, a priori, false narrative. It's not the defamation case. This is not the harassment case, the criminal harassment case that's proceeding with respect to Mr. Carney in Norfolk County. And so
we're well aware what the fuck it's not. Didn't he just ask when you could have a conversation? How are we this far afield after can you guys get together for a conversation?
we're happy to consult with them, look for more stuff. I think there's a disconnect because there's a different view of what happened here. And so I think
you did not. Was he going to say there's a different view of reality? Or was that just my brain filling in the gaps? I had to back it up.
we're happy to consult with them, look for more stuff. I think there's a disconnect because there's a different view of what happened here. And so I think they're frustrated when we say we don't have any documents because he simply doesn't have any. He searched. We're willing to consider searching for more and expand the time scope of that search, but in likelihood the answer is going to be the same.
I understand you stand before me representing a non-party.
Yes.
But we're all aware of the other case in which certain allegations have been made. So you're going to have to do.
I appreciate the court. The court is like, hey, we can all pretend that he's a non-party in this case because he is. That's not pretending, really. We all know he's a non-party in this case, but let's not ignore the fact that he is a party in the other case. We know that this is discovery in that case is also coming. So I appreciate that the court is like, we know that he's a party in the other case and it changes.
Some of those searches sooner or later.
Of course, Your Honor. I think what I'm just trying to do, I think, follow.
The end of what the court said that I stepped on was, look, we know we're going to end up doing these searches at one time or another. Right.
Certain allegations have been made. So you're going to have to do some of those searches sooner or later.
Of course, Your Honor. I think what I'm just trying to do, I think, following the guidance of this court, this case is the wrongful death case. We're going to do discovery, and we're doing discovery in the defamation case, and we're going to get document requests, I'm sure, that will be broader than that. That's a different case here. And so the issue I have, Your Honor, as a third party here in this matter, is resource issues, right? It's quite expensive here. We're going to have to do this in the defamation case. That's going to be different.
Aren't resource issues maybe the reason that they didn't want to take the deposition before they got the documents? Shouldn't that be recognized then? They're like, these are resource issues. Okay, but you're going to have to do it at some point. So why do it? Okay, never mind.
And separate apart from this one. So all I'm trying to do, Your Honor, is kind of ensure that not needlessly harassing a third party here in this action. I appreciate what you're saying, Your Honor. We're going to produce those documents in response to the RFPs when we get them, right? Obviously we are. We've already gotten one set of RFPs from Ms. Reed in that case too. So I do appreciate it. I'm standing here as a third party, subject to the protection.
RFP or the request for production. He's saying, yes, in the other case, we're going to do the discovery that we have to do. We're going to respond to the discovery we have to respond to. We're a third party in this case. We don't have to. We want to keep it more narrow in this case. So RFP means request for production.
Sections of Rule 45 in this matter, and my client in this instance is also a party to a defamation case originally filed in Barstow County, now appearing before Your Honor. But I think in terms of like the scope of discovery and forcing him to kind of like do duplicative discovery, that's a little excessively burdensome. And so I think it's appropriate to keep our focus on what they want for this case.
How?
Like I mentioned before, it's not before Your Honor.
How is duplicative discovery unduly burdensome if you're just turning over all the same stuff in both cases? Maybe I'm missing something. I don't see how that's unduly burdensome other than to say this is what we've turned over in this case, same.
We had thought that consolidation for discovery purposes might make sense to avoid this kind of situation, and it was rejected. That's fine. I'm not asking you to address it.
Somehow I don't think the hospitality defendants would really want to be one.
I will tell you, Your Honor, they actually said okay. I'm not to speak for them, but they said okay to it. But that's these issues that I'm dealing with, Your Honor. I appreciate what you're saying with respect to the defamation case and discovery in that matter too. But that's why
I don't know if the plaintiffs in this case want this all consolidated for discovery because it's going to extend the discovery deadline. Also, how would the bars, I don't think, care, honestly. I don't necessarily disagree that the bars are just like, y'all do whatever. So by hospitality defendants, he's talking about the bars, the restaurants, the Waterfall and CF McCarthy's. On the defense side, taking more time for the bars might not really impact their case one way or the other. So they're like, whatever, you guys want to consolidate this all for discovery? It has nothing to do with us. Just, knock your socks off, do whatever, we're fine. But it could delay the case significantly for the plaintiffs. So Chanty said, did he say hospitality defendants? Yes. He means the bars. The bars are just sitting there going, oh, apologies, that's me. The bars are all just sitting there going, tea. But the hospitality defendants are the restaurants, the CF McCarthy's and the Waterfall. All right, let's continue. That was my calendar that scared the crap out of me because I've got this turned up super loud. Apologies, chat. Continuing on.
why here, I think the appropriate scope for this case is, as you've laid out before, which is what happened to Officer O'Keefe on that night. And on that point, as we put out in our briefing, Colin Albert simply doesn't have a lot to say.
He's just going to start arguing.
Yeah, we'll consider Bert. No,
What depositions are scheduled for Monday? And I should know because I asked you for the calendar, but I don't remember.
You know, Dan? Monday is...
The court ordered them last week to turn over a list of everything that they needed. And now the court's like, whose depots on Monday? Do you not have it in the file, Your Honor? Tell me what the depots are. And the lawyers are like, I don't know. I'm not sure.
Monday is Nicole Albert, but that's going to be that's a subject of a separate motion to compel. That's pending via 9A. That's going to be filed.
So Monday's deposition is supposed to be Nicole Albert, and Reed's team is saying there's going to be a motion to compel. When's that getting filed? Today? Is that getting filed today then? Okay.
Hopefully early next week.
Great. So, hate to ruin your weekend.
So that's not happening.
You and your team can review what you got today, and the two of you can talk. We can all come back Monday afternoon at 3 o'clock. Talk about this again. Does that work for everyone?
When you said your team, were you talking to Mr. Buck? Okay. Let me just make sure.
Zoom or in person?
Did you hear what the court said? I want you all to be back on Monday.
In person.
Perfect.
Yes, that works.
I will not be available, Your Honor. I think I mentioned this at our Rule 16 conference. I'll be gone for a while.
Maybe you have someone that could report on the results of your discussions.
Certainly, I can do that, Your Honor, and that's part of the issue with respect to resources. Obviously, I have my colleague, Kieran Murphy, who's here with me, pro-hocked into the defamation case. It costs money to do that. It's not cheap, so I can try to find someone in my office to respond.
How much does it cost to pro-hawk somebody in? Also, isn't your firm in Massachusetts? Why do you... I got questions. But whatever. He's saying it's not cheap to pro-hawk somebody, and okay. But don't you have a Massachusetts firm? Okay, whatever. But he's like, I'm not available Monday. All right, well...
He can respond without appearing before Your Honor, and then we can figure out...
We have no objection to making that easier, however we can.
Say that again?
To the extent there's a way that Mr. Murphy can appear, we're fine with it.
But we'll let him appear, right?
Yes, I mean, I'd asked today.
I like that the other side's like, we don't really care if he's not pro-hawked in. He's fine. It's a calendaring conference. It's fine.
Hey, I understand that he's not pro-hawked into this case. That's all.
We have no
Don't tell
objection.
anyone, okay?
The court's like, don't tell anyone. Okay. Okay. Why does this attorney need to be pro-hawked in?
After you talk with Attorney Rosenberg.
Yes.
Anything else? You have other motions that are coming?
Yeah, we do. We have a motion to compel that's coming. Again, next week. I think the opposition is due early next week. It'll be filed with you shortly. There's one pending motion from the plaintiffs, I believe, seeking additional information in response to interrogatories.
And then there's a pending motion with regard to MSP, I think.
That's it, I think.
At the moment, I believe that's accurate.
But that's set for hearing.
Okay, well, see if you can agree amongst yourselves as to a date to have another hearing.
Oh, that makes
June
sense.
29 on those motions.
Again, grew up in California. How close together the East Coast can be makes sense. Attorney Murphy is from New York. Well, then that explains why he needs to be pro-hawked in. For those of you asking about the pro-hawk vice is attorneys appearing in a case, even if they are not barred attorneys in that state, for one matter only. And then they have to be pro-hawked into each case. So like Alan Jackson is a barred attorney in California. When he appears in this case, the court needs to allow him to appear in the wrongful death case as an attorney that's not barred in Massachusetts. And that's the same in the wrongful death case, the defamation case, if he is an attorney on the defamation case, for the case against the entities MSP and Canton, and for the federal case. So if you don't go here, you have to be admitted for literally each case if you're going to appear on the record. Lawyers can work on a case, but they can't appear on the record unless the court accepts them as pro-hawk vice. Victor Mann, thank you, Victor. Victor said pro-hawk in Massachusetts is $355 based on Google. That's not really $350. We're arguing about $350. I know for a lot of you, it's like, Emily, $350 is when we're talking about this type of litigation. It is not, this is not earth-shattering money in this litigation. This is when dealing with litigation like this, that is not that is probably lower than their billables. Okay, whatever. Sure.
Soon to be filed, all right? You don't need to do it right now, all right? Anything else?
Can we address one topic at sidebar briefly, Your Honor? Thank you.
I turned down the volume for the sidebar. I'm going to turn it down even further. I'm going to answer some questions while they continue to be at sidebar because they show what everybody in the audience is doing, which I always find interesting. I find it interesting that one of their arguments is like, we can't be here on Monday because the pro hoc fees are expensive. I was expecting them to be more than that. And all the other lawyers are like, this is silly. But you do have to be pro hoc featured in for each case. So I'm going to answer some questions while the attorneys are at sidebar in this hearing, because it is quite a lot. Crystal Dagger said, active duty Army officer here. Crystal, thank you for your service. The military will comply with court cases, ensuring the individual goes to court or at the very least is available to video chat. I had to fly soldiers back from deployment for court. I agree with you. I am so thankful that you have confirmed what my common sense is telling me, which is this shouldn't be this crazy. I understand that basic training might be a little harder to navigate around, but it sounds like basic training hasn't even started yet, that he is doing 3 weeks of something before basic training, and that this all could have been navigated. But of course, everything is a fight. And we have seen how much everything has become a fight in this case, with the attorneys just being like, but they should be sanctioned for saying that he failed to appear at his deposition. It's just a lot. Richard the Magician said, don't you have to let the Army know if you have pending court cases? Yes, that is my understanding, that they would need to know about it. That is absolutely my understanding. And the court, yeah, that's my understanding. So I don't know why this is still a fight, because the court's like, no, we're not waiting till the fall. Bring him for deposition and make it work. Lawns and Order said other people's procrastinations. So much fighting. Just a lot. JPH said, honestly, I want to know if Colin joins the Massachusetts National Guard, reserves, or active duty. I do not know, but they said Army. I guess we will see. It's I don't know. And I am curious how all of this plays out as we get further into he can't be deposed, but he can be deposed, but he can't be deposed, and all of the rest of it. It's just so much. Anonymous says he's trying the Beetlejuice method. Say it 3 times and it becomes a reality. It really feels like that's where we're at. But Your Honor, they said he failed to appear at his deposition and it's not true. It's exhausting. All right. It looks like they're coming back from sidebar.
So the next date we have is Monday. So we have next Monday, and after that we have 9:45 on the 26th for a
9:20. They are back in court Monday.
status.
That's still by Zoom, Your Honor?
Yes.
Okay.
Monday's in
Thank you very
person.
much.
Thank you, Your Honor.
See you on Monday.
That's it.
All right.
Next, the matter is continued to June 22nd, 2026 at 3 p.m. in person for the hearing of this motion. Thank you all.
So, y'all sort it the fuck out and get back here on Monday. As they pack up, I'm going to continue to answer some questions. We'll do a summary of this. And I really do want to go peek real quick at what was said on June 3rd that everybody's making such a fucking big deal out of. I'm curious, for sure. For everyone who gifted memberships, thank you. To all our new members, thank you and welcome. I appreciate it. Let's see. We were talking a lot about the Tartan Army yesterday. We talked about it some today. Not the army that Colin Albert is joining. The Tartan Army donates to charities in the areas they visit. I think that's amazing. what a great way to kind of honor the locations that you're visiting. I mean, in addition to the amount of money I'm sure they are spending on beer to be a boon to the economy, but it's fantastic. I think that's a great tradition. I really, really love that. I love that. I love that a lot. So I'm going to let this continue to play at the end of court here, and then we'll summarize it. That's what I said. Oh, we're done. Okay. Because I edited the sound. I added music at the end. So then I know that it's done because I'm curious. Let's see. Emily, do you have the second document that was on the docket for a short period of time where Damon Seligson was clarifying the record? I didn't see it on the docket. I can go look for it. Not for today, but I can go look for it. I want to go see what happened at that June 3rd hearing because they just made such a big deal out of it. And I was like, it's not that big of a deal. Or at least it doesn't seem like that big of a deal to me. And whenever somebody's making that big of a deal of whatever, I have questions. Because there are some things that are worth being made a big deal about. And there are some things that it's like, is this really it? So the court punted. That's where we're at the end of the hearing from the afternoon of Wednesday, June 17th. The court punted. The court said, look, at the beginning of the hearing, I want all of you to stop it with the hyperbolic filings, my summary of what the court said. I want just the information that is helpful. I want you to stop posing arguments as facts. Essentially, I want the temperature to be taken down a notch. Attorney Rosenberg was then like, but Your Honor, we had a really constrained filing and then they filed that opposition. So it's really not us. And the court's like, oh, you want to go line by line? Let's go line by line. There are direct quotes at the beginning of this motion. That direct quote being pin it on the girl. And the court's like, that's not attributed anywhere. Who's that quote attributed to? There's a direct quote and no attribution. This is what I'm talking about. And then Attorney Rosenberg was like, that's attributed to her defense attorney. And the court's like, right. Why is this in here? Why are we doing this? And then when he looked at the other side of the table, he's like, hey, counsel, subpoenas have to mean something. Your client has been subpoenaed. When is he appearing for deposition? And Colin Albert's attorney is like, the fall. And the court's like, that's not what we're doing. What we're not doing is the fall. We are not waiting till the fall for this deposition. So I need you to tell me when your client is being made to appear for deposition, which is essentially the court saying that they are granting Karen Reed's motion to compel, that Colin Albert is going to be required to sit for deposition, that Colin Albert is going to be required to turn over more documents, and that the attorneys, the court is like, take the weekend and sort out your document discovery. Because you've got to find the Goldilocks zone. This is too broad. This is too narrow. Find the just right. But you're going to have to turn over discovery. And the court did note to Colin Albert's attorney, we know that Colin Albert is a party in another case. So though he is a third-party witness here, the rules are a little different than that. He is going to have to do these searches for discovery at some point. So the court was pushing back on, I understand he's a third-party witness here, but let us not pretend that he is not a plaintiff in the defamation case that is also before this court. You are his attorney in that matter. And you are going to have to do these searches for discovery at some point. And then Colin Albert's attorney responded, well, we don't want discovery to be duplicative. I don't understand how doing a thorough search once is duplicative to doing a narrow search and then a more fulsome search. But maybe it's just me. So the court pushing back on how overwrought the filings have gotten, asking everyone to tone it down. We'll see. Asking everyone to take down the fighting a bit. And then saying, I want all of you back here Monday to explain to me when Colin Albert's doing his deposition. So they'll be back in court on Monday, and I imagine that that's what we'll be covering on Tuesday, because I am curious when everybody's going to have to go to deposition. But the discovery deadline in this case is August. Emily, how long until everybody's filing motions asking for the discovery deadline to be extended? July. That's going to happen in July. Yeah, that's going to happen in July. because the way that they're fighting about this, I do not think they are going to get this done. But the reason the court would not extend the discovery deadline yet and is going to hold them to that deadline is that deadlines can foster urgency. But with the way we've seen this court rule, I would be very surprised if they said we need more time on the discovery deadline and the court said, no, you're stuck with what you got. Because every time people push back, he continues to give more time. He is trying to hold them to that August deadline, but when pushed, he has consistently said, okay, come back here a few days later. It's going to be discovery death by 1,000 cuts at this point. It's the same thing with Proctor's Depot. It's frustrating. Instead of just saying, motion denied, go do your deposition in 30 minutes, the court said, okay, we'll be back here this afternoon. And then he said, go to your depot tomorrow. And all the lawyers are like, we can't do that. And then it pushed it back out. And I don't know what their next date is for that depot, but it was pushing it back out at least several weeks to the end of June, if not the beginning of July. And all of those little inefficiencies are going to land with all of these attorneys saying we're not done. And I guess we'll see what happens on Monday and how this is all going to work. But we also heard from Colin Albert's attorney, oh, he's in basic training. And then it was like, no, there's a 3-week school before basic training. So he's not in basic training yet, but he is in 3-week school. And we don't know where basic training will be. And we don't know if he's available. And the court's like, when is he coming to the deposition? Make it happen. Make it happen now. So with all of that, I am very curious to just take a quick noodly peek. A quick peek at what happened on the 3rd. And that is something I'm interested in. So we'll take a look real quick. Let's see. I am going to try to get to as many questions as I can, but a lot of them are comments that I see. I see what you guys are saying in the super chats. I was just trying to get to, my meeting because we have chatted for a very long time today. I have chatted for a very long time today. And B, I really do want to take a quick peek at that hearing. You guys, we're good to peek at the hearing. I'm really curious. I am. I think you are too. I'm really curious. They said it was about 17 minutes in.
Good afternoon, everyone.
We're going to try to find that point of the hearing and kind of zoom a little bit to get to when they were talking about these depositions. I believe it was kind of towards the end of the hearing. So we're going to back up a little and take a look at the hearing from the 3rd. All of you are like, yes, please, let's take a look at the hearing. Because, what could be so egregious? What could be so egregious? Let's see. I think we're right in the right spot. I'm going to start at about 16 minutes in, even though the timestamps were for 17 minutes, just to get us a little bit of context from this Zoom hearing. We already covered this hearing, the entirety in another stream. I am just peeking back in because I'm curious. I'm curious. You're curious. All of you are like, let's take a look. We're all curious. So sorry to the attorney at the bottom who is half covered by logo. Let's see if I can just embiggen myself just a little bit so we're not covering up all the way, but enough. All right. Regardless of the hearing, I'm real curious. This is where plaintiff's counsel is alleging that the egregiousness of the egregiousness of statements that Colin Albert had not gone to his deposition came from. And this is where that fighting, it seems to have begun. So let's see. Let's see what happened and what was said on the record and in what context, because I remember it was the court asking about why the depots aren't done. Like, why aren't we getting it done? Why aren't we getting it done better? And what's going on? I'm going to try to kill some of the space around this Zoom just so it's the attorneys are a little bit embiggened. That is more visually pleasing. All right, let's go. Let's take a look. We should swoop. Still in Massachusetts, jumping in our TARDIS and going back in time just a little bit. Let's go to court.
What, if anything, can the court do to help the parties?
I do not know how. I just queued it up to 16 minutes. And I'm going to leave the closed captioning at the bottom so it's not covering Diller's expressions. I do not know how I queued this up to immediately start with a what if anything. That's hilarious. I just went to 16 minutes. That's funny. That's funny.
What, if anything, can the court do to help the parties
That's
other
funny.
than to act expeditiously on any motions that may come before me?
That's all from our perspective, Your Honor.
We'll involve the court with some of the issues that we have outstanding and ask the court's indulgence to act expeditiously.
So what motions have been sent out under 9A and can I expect to receive shortly?
From Ms. Reed, Your Honor, I believe the only pending one right now is a motion to compel production and deposition of Colin Albert.
So the court specifically asked what motions are pending.
Then there is, I believe it's likely that you'll see similar motions relating to the 6 other individuals that I listed. But we just found out last night that they're apparently unavailable.
I didn't hear the last part of that.
Sorry, I said
The court said, what other motions? Well, we're going to have a motion to compel regarding Colin Albert. And then apparently with regard to 6 others, because at the beginning of this hearing, Attorney Rosenberg said, I got an email late last night saying all of the other witnesses are unavailable.
As I said earlier, we've only just found out last night that they're apparently unavailable, so that motion hasn't been served.
Did the notice of unavailability?
Stephanie said it's been 2 weeks and they haven't filed those motions. They've served the motions, Stephanie. So in Massachusetts, and this is what they were talking about in court today, and I hope it's helpful to clear up. In Massachusetts, the party, in this case, Rosenberg Reed, would file the motion to compel served on the other party. The other party then responds with their opposition. Reed's party then does their reply, and then everything goes on to the docket at the same time. So at the end of the hearing that we just watched from yesterday, he said that there is one regarding Nicole Albert, and then there are others pending. But they serve the motion on the other side opposes, then the reply, then they go on the docket. So they do not hit the docket until all of the motion practice is complete. So they said that they have served some of them.
Availability indicate any reason or other than they just can't be there?
Rosenberg and Seligson both went, nope. The court's like, is there any reason that they're unavailable? And both of them were just like, no, Your Honor, we have no idea.
It says, with respect to the depositions, our clients are not available on the dates proposed in the subpoenas. And then their availability is as follows, almost entirely late July and August.
Rosenberg is reading from the email sent from attorney Jim. So that's from Jim. And this is regarding Jim's clients. Jim's clients aren't there at the moment. Jim's clients are not in this hearing. And that attorney is not present in this hearing. But the court's like, what motions are we going to need? And he's like, we're going to need these motions to compel.
That's it. So we'll confer and try to work that out and get them sooner than that. But if not, you should expect those motions.
Attorney Seligson, did you find the date when they were first noticed?
Yes, Your Honor. They were noticed. Depositions went out on May 5th for various dates in June and May.
And Attorney Rosenberg or Attorney Seligson, how did they get kicked over beyond that? Because it's June already,
Those are the dates so Colin Albert refused to appear and refused to produce documents, said his...
This is what they're mad about. So the court is going back and forth on why the fuck is this taking so long? And this is what half of that motion that we went over today was about.
Beyond that, because it's June.
Why is it taking so long?
Already.
Those are the dates so Colin Albert refused to appear and refused to produce documents, said his attorney said he was unavailable, and then out of the blue said, now he's only available for another 7 days and then he's gone for the rest of your discovery period. So that was that deposition. The other ones are the ones that I've been referring to today. They've gotten kicked out because we just found out that they're apparently unavailable.
It's good to hear that someone's paying attention to what the deposition discovery deadline is. I'm sure you all are as well, and I anticipate there are going to be motions forthcoming, but nothing's guaranteed here.
From our perspective, Your Honor, all we're trying to do is get it done in the current deadline. I mean, we're with you, and that's why the dates we got last night aren't.
So he says he refused to appear, refused to produce documents. His lawyer said he was unavailable, and now he's only available for like 7 days and what have you. Okay. And then Rosenberg said, okay, refused to produce documents and didn't give us a new date. There, does that clarify it for you?
Aren't workable because it's going to jam everyone up on this call unnecessarily. So we'll try to figure it out. If we can't, we'll bring it to you quickly.
Your Honor, I don't agree with what has been created as a record here today.
I'm curious to see what Diller pipes in to say. A number of you are asking, is this the same judge we just watched? Yes, this is just the Zoom version of it, not the in-court version of it. And a number of you asked, well, why aren't the third-party lawyers there? Because it's not a motion pertaining to them. So it's not a motion pertaining to them. It came up because the court was asking why this isn't moving along. And they said, we're going to need to file these motions to compel, and this is why we need to file the motions to compel. So the third-party lawyers shouldn't be there for this. They're not obligated to be there. They shouldn't be charging their clients for it because the court is now asking for things beyond what the hearing was about because it's a status conference. And he's like, when are y'all going to be ready?
But I'm not looking to get
You're interjecting.
Specific unless this court wants me to. But I just want to say that I don't believe that what was created as a record here for you today is an accurate assessment of how things have transpired, notably with the Colin Albert deposition as well as with some of these other ones.
How would you know that?
Well, I know that because we conducted the deposition of Colin Albert last.
And this is where everything was so confusing. And I asked her, Stephanie, 10 out of 10, Diller, I was in the room where it happened. Yes, he just wants to say it. This is what got so confusing because Diller was then like, oh, I was at Colin Albert's deposition. Court, how do you know that?
How would you know that?
Well, I know that because we conducted the deposition of Colin Albert last week. And what had happened originally was...
This explains why Rosenberg is like, the fuck? This is why Rosenberg was laughing.
That deposition was scheduled in February. It was noticed in February. We blocked the time to have it occur in late April. There was never any subpoena. So that's why I'm using the distinction between a notice of deposition to us, and we were of the impression...
I forgot how much Diller inserted himself into this whole thing.
Professionally, that we were going to block our calendar and prepare for those depositions, to which we did. That deposition was supposed to take place, I want to say, on or about April 29th. At the 11th hour, that deposition was canceled. and I'm told it was canceled by the Reed team. Then it
You were told that by Jim, right? That was when you and Jim were chatting? Right.
was never renoticed or put back on the calendar. Sometime on...
Hang on, Attorney Diller. I'm sure at some point in the future, I'm going to be asking, in response to requests for more time, exactly what transpired in the past.
And then the court cuts
relative
off Diller.
to various prospective deponents.
Yep.
So I'll have a chance to look at all of that. But, and again, I don't mean to be dismissive, and I hate to use the word nitpicking, but I just don't want to hear it.
I hate to be dismissive, but can you all shut the fuck up? I don't mean to be dismissive, but I don't want to hear it. Stop it. I don't want to hear the back and forth and then. A few of you are saying, I must have missed this the first time around. We didn't have the same context. We were the ones that were not in the room where it happened. We didn't have all the context in this as they were jumping in. When we watched this on June 3rd, we were like, what the fuck is going on? We have a lot more context now, which is why I wanted to jump back in time and revisit this now that we have more context.
At this point, that
I understand, Your Honor.
pointing fingers. So what productive things can we talk about today?
What productive things can we talk today? Oh, the court's like, stop it. The court literally was like, zip, 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 www.zipit.com. The court was done. I'm glad we revisited June 3rd. I forgot how much Diller had like parachuted in to be like, well, we took Colin Albert's deposition. Oh, the fight over these depositions are not going to end anytime soon. Law nerds, thank you for allowing me to go back and revisit that hearing from June 3rd. We will link down in the description the entirety of the hearing. I did not anticipate us to be streaming for 5 hours today, which is why I have got to scoot. I really didn't think that reply. I didn't think it through. I did not think that reply was going to be that many pages. And I didn't anticipate how verbose it was going to be. But now we understand some of the discord between the attorneys because it is not going well. But now everything makes much more sense. All of the fighting behind the scenes continues to bubble to light in the emails and the hearings and the things we don't always have the context for until we revisit them after the motion practice. And now we know that on Monday, they will be back in court. They're supposed to have a deposition for Nicole Albert, but there was a motion to compel. I wonder if the motion to compel is regarding documents. I suspect that it is because we saw some of that brewing in the motion practice. It still boggles my mind that not that Nicole Albert, Chris Albert, and Colin Albert all have the same attorney. It's not surprising to me that the two married parents and their son would have the same attorney, but that those Alberts, Higgins, and the McCabe's all have the same lawyer boggles my mind. But yes, they do. So that's why we're seeing this stuff spill over, because it's the same parties fighting with each other. And that's why we saw Jim including every single subpoena saying they're all overbroad. All of these subpoenas are overbroad. All of them are too broad and we're not responding. So I'm not surprised that we are going to probably see 6 more motions to compel, or the attorneys are going to have a meet and confer and agree to a scope of discovery. Also keeping in mind that these parties are also parties opposed differently in other litigation. So we will see. Because at the end of the day, all the discovery is going to have to be done because they chose to sue as well. So they're not just third-party witnesses, they're also plaintiffs in another case. And the court, I was glad to hear the court point it out and say, let's not pretend that there's not another case ongoing. And that case, the defamation case with those parties, is back in court for hearing, just so I can remind myself, where is my internal docket? That defamation case is back in court on July 14th. So the court has set a briefing schedule for any slap or anti-slap motions, and that briefing is going to be coming up at the beginning of July. So there's still a lot of litigation going on in the other cases here, and court dates that are becoming up pretty quickly. So all of these attorneys are trying to do depositions, but also are going to be doing motion practice. And that's why when the court is like, well, you have 1 million lawyers and 4 different lawsuits. In these lawsuits, the only person who's a party in all 4 of them is Karen Reed. So I'm not surprised that she has the most attorneys. Now, the McCabe's, the Alberts, and Higgins are parties in 2 of them, but Karen Reed is the only one who's a party in all 4. So when the court is like, she's got 10 lawyers, she's got 4 cases that are all different. And with that, law nerds, thank you for being here. Thank you for being a law nerd. I am going to go to my meeting. Stay safe with your weather today if it gets spicy like it is for me. Don't forget to get the Law Nerd app to stay in the loop. I will see you soon. Apparently, we're going to be back in court on Monday, so we'll talk about it on Tuesday, and then maybe we'll get to talk about some other stuff. But we'll do that on the podcast too. So don't worry about that. We'll be talking about it. And if those docs are updated, I will try to get those updated documents into the Law Nerd Lounge in the next day or so. I'll be working on that. So Law Nerds, it's good to see you. Thank you. I got to scoot. Have a good rest of your weekend. Have a good holiday tomorrow. Enjoy the weather if it's nice. And I will see you soon. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.